Proceed.
Mr. Speaker, time is past 10:12. I therefore move that we suspend this to 5 to 12.
Any seconder? Any seconder? What's wrong with your mic?
I so second, Mr. Speaker.
I'm going with him. Give him the mobile mic.
I so second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it.
The record of votes and proceedings for Tuesday, 4th August 2026.
Proceed. Okay. Honorable members, the record of votes and proceedings. Pages 1 to 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. 13. 14. 14? Page 14. Yes, Honorable.
Mr. Speaker. That remains 2.
Which one? 14?
No.
Okay, page 14, page 15, and 16. Can the member please move?
So, Mr. Speaker.
Any seconder?
So second.
All those in favor say aye. Those against say nay. The ayes have it.
The record of votes and proceedings for Tuesday, 4th August 2026 has been adopted. Announcement by Mr. Speaker.
We proceed.
Bill, the Constitution of Sierra Leone Amendment Act 2025. Committee stage and third reading. The Attorney General and Minister of Justice. The House is open. The House is also to Committee of the Whole. Debate continues.
We're on page 13. Page 14.
Yes, Mr. Chairman, page
Speaker.
Yes.
Oh. Mr. Speaker.
Yes. Proceed.
Chairman, honorable members, with your leave, I beg to take us back a little bit, just a little bit, Mr. Chairman and honorable members. Mr. Chairman, honorable members, you recall that during the last debate, we discussed the inclusion of the provisions in the Guinea Act into the Constitution. And for that, we are grateful that honorable members of Parliament, have.
Hold on, that is on which page? 10 and 11. Page 10 and 11, not so?
Yes, Mr. Speaker.
Proceed.
And that was.
Oh, sorry, I don't think it's page 10.
Not 10 and 11.
We can go back. It has to deal with the amendments on
Section
clause
35.
35.
Yes.
35.
So clause 3, section 35 of the Constitution. So that's
Which
page 5.
page? Which page? Of the
Page 5.
Page 5. That's on page 5.
And then later page 7.
Yes.
Yes, agent.
Mr. Speaker, honorable members, we did indicate that section 35 has to do with the conduct of political parties. And so we believed that any such addition should be included in the exercise of executive authority. Mr. Speaker, Mr. Chairman, honorable members, the proposal ties in with a call that was made by His Excellency the President during his last state of the opening, which is his last statement before this honorable House. He called on us to have a genuine dialogue about proportional representation, including in the context of executive authority. We note that that particular call generated significant debate across the country, whether that meant power sharing or something else. Noting that call and the debate that followed, and going by the proposal that was made by a member of the opposition, Honorable Kamara, or that we extend similar commitment to the constitution of the executive arm of government. We now propose, Mr. Speaker, Mr. Chairman, honorable members, we propose an amendment to section 59 of the Constitution. Section 59 has to do with the establishment of cabinets. With your leave, I'll read some portions of it. There shall be a cabinet whose functions shall be to advise the President in the government of Sierra Leone, and which shall consist of the President, the Vice President, such ministers as the President may from time to time appoint. And then, of course, there's section 2. A person appointed as minister of a member of cabinet shall vacate his seat in the cabinet if he ceases to be a minister, President directs. Mr. Speaker, we would propose a renumbering of this particular section, but with the inclusion of a new subsection to read that in appointing ministers under subsection 1, that of section 59, the President may give consideration. The President may give consideration as far as practicable to a. No, I said may, not shall. The President, in appointing ministers and deputy ministers under subsection 1, the President may give consideration as far as practicable to a. the political diversity of Parliament, b. the regional and district balance of the Republic, c. gender equity, in line with what will now read at section 35, the subsection provides under section 35, and then D, the inclusion of minority groups. We will propose the inclusion of this subsection under section 59. Mr. Chairman, honorable members, this is important because it is our firm belief that government across all sectors should reflect the diversity of our country, should be inclusive, and should be representative of the people. And we believe that in addition to the requirement that has been made of Parliament, I'm including this for the President's consideration in constituting his cabinet or cabinet, will be a significant step towards achieving the goal of inclusion, participatory governance, and diversity of our country. I so submit, Mr. Chairman, honorable members.
You are my boss. No, you are my boss.
Mr. Chairman. Yes, let me hear the opposition on this.
Mr. Chairman, many things are not clear in what the minister is proposing. And we are making laws. There are certain ambiguities that must be laid very bare. Two things. One, he quoted me, and what I pushed for was a mandatory clause on 30%. That if we have 30% in Parliament, I believe we have capable women in Sierra Leone that can address, that can fill in every given opportunity. So if he's quoting me, I wanted to be quoted right, that I said shall. The other thing he mentioned when it comes to the issue of appointment is in proportionate to the configuration of Parliament. You know, I have said it is good we come clear with our intentions and we try not to cover up and create a situation as if we on this side are not thinking. What we are doing here, when you speak, we listen, we think, we process at the same time. We are not begging for a power sharing situation. And if we said no to it before now, we still start to say no to it. If the situation of regional balance, the president should do everything possible to have a regional balance in cabinet, correct? But if you tie that to proportional, the configuration of Parliament, tell us clearly you want to propose IPI at the executive arm of government. If we accept as a people of Sierra Leone, we accept. If we don't, we will not accept. But trying to...
So what is debatable?
What is debatable is the position he has made that, first of all, I want him to be clear with what he said, which is not clear. I am sure most people who are here do not understand what I am understanding.
I'm trying to explain it. Hold on, explain what you understand.
So explain what you understand.
Yes, proceed. Honorable members, order.
We had a meeting with the Speaker's Conference. Those are the directives on the first day of sitting. And of course, ourselves and the Attorney General, we agree on this issue. But I have got anything. Yes, I move it. You are right, sir. We agreed on this issue. But my problem now is that, for me, I agree with him, but not on section 59. Earlier, I agreed on section 59. But now I've got a thing. But section 59 is limited only to cabinet. That is one. So I'm suggesting a rephrase of the opening paragraph, but standing on section 61 instead of 59. Because section 69, section 61 covers both cabinets, ambassadors, commissioners, board members, director generals. It covers everything within the president's power. So it's like saying, in exercising his authority under section 61, the president may, we agreed on that may, because even in the GUE Act, the clause there is may. In the GUE Act, we agreed. Although if I had known at that time, I would have disagreed. But unfortunately, it was too late for me. So it is made in the GUE Act. So that is why the exercise of presidential authority to appoint 30% of women, we still agree on May. But if the GUE Act is scoring more votes, even on that May, I think we can continue to score that. But we don't want to limit it. GUE Act limited it to only elective positions. We want to include now appointed positions. But section 59 limited appointed positions of cabinet only, while 61 covers all. So I'm suggesting that we rephrase, but we stand on section 61 instead of 59. That will cover everybody, and that will be good for women.
Thank you very much. Honorable Giver.
Thank you, Mr. Speaker.
Okay, hold on briefly.
Mr. Chairman, honorable members, two issues. First to Honorable Amkani Kamara, just to make some clarification. My reading of this.
Hold on, Mr. Minister. I said Honorable Giver. Are you not debating anymore?
No, I'm debating.
Please hold on. 1 minute.
Thank you, Mr.
Hold on, Mr. Minister.
Mr. Speaker, I am sure this idea is a welcome idea, even for those who represent in this House, hearing the Attorney General and the very reasoning of it. Every Sierra Leonean warm up to this idea that what was mentioned by the President during the last state opening of Parliament, that the proportional representation being extended to the executive arm of the government being something that we think of. And like my learned colleague has said, I will agree with him as well, but that it could still fit in section 59. That if you are introducing it in section 59, you can still spell out ambassadorial position. Because section 59 is also dealing with the appointment of ministers or the power of the president in exercising his powers in appointing ministers and the like.
Mr. Chairman, if he is suggesting the inclusion of ambassadorial, what about board members? What about the director generals? What about the executive secretaries? Section 61 covers all that in the opening paragraph.
It's all right.
That is one.
It's all right. I please give the minister 1 minute. Just respond to the issue.
Okay, thank you, Mr. Chairman, honorable members. Just to say, to clarify, in reading out this proposal, there was no use of proportional, apart from the President's call for a genuine dialogue. And so the reading of it in relation to Parliament, I did not say proportionate. I said in appointing ministers and deputy ministers, the President may give consideration as far as possible to the political diversity of Parliament. I didn't say proportionate. Those are not my words. But just to say, Mr. Speaker, honorable members, we we take note of the intervention made by the deputy leader of the opposition, and this is to note that we will agree in entirety that this provision that we seek to introduce in the Constitution be put under Section 61
I totally agree. I totally agree. Not 59 or 61. I totally agree. No, don't debate that.
No, I am not debating that.
Don't debate that.
No, he has quoted me. No, that's the issue.
Forget about quoting you. Forget about quoting you.
No, it's not quoting you, Mr. Speaker. We are making a law.
It's all right.
And he's saying,
It's all right.
let's not be all
Do
right.
you know why I'm stopping you? Because of relevance. We are not here for whether it's quoting you or not. We are dealing with the provision.
Thank you. And that is what I have a problem with.
No, your argument is not relevant to the proceeding.
No, it's not how relevant I
Forget about whether it's quoting you or not.
I am, Mr. Speaker.
Don't refer to quoting you.
No,
refer to the provision.
That's exactly what I'm referring to. Mr. Speaker, the minister is very clever presenting this issue. And he has come very clear that the president can appoint in line with regional balance, which is correct. But if you tie that to the configuration of parliament, it signifies political parties in parliament and their strength. So we are saying for national balance, which is what we seek to address since the starting of this constitutional review, let us limit the appointment of president to reflect regional balance, which is just an against all other issues. Because even when you talk about political strength in parliament, the political parties are the configuration of the country. So if you say, for example, each region should have equal representation on cabinet, it surpasses political representations at parliamentary level. That's just my position.
It cannot be equal representation. Mr. Minister, what do you see? Before
Mr. Speaker, I don't see how this is. You use one not to the exclusion of the other. If you say, even without this provision, the president is free to set up a government or make appointments reflecting the regional balance in the country or the political diversity. We basically will just say it's an issue of will, not an issue of shall. It's something that the Constitution will encourage the president to consider. The political diversity of parliament, or if the honourable member feels so strongly about it, we could change parliament to country, and then the regional balance, gender equity, etc., etc.
Is there anything wrong with regional balance? Is there anything wrong with that? Are you okay with regional balance?
So it is there already under B, it's a regional and district balance of the republic. Okay. But we
regional and district.
Yes, but the A part of it is the political diversity of parliament.
No,
That's
hold on. As long as regional and district balance.
And then of course,
to that, even if you mention, the representation in parliament, all of those are not issues for debate.
that's
Because you have given the discretion to His Excellency the President, then you don't have to limit him. You don't limit him. Let me state one point. Honourable members, let me state this point. Let me state this point for all to understand. The office of the President should be a very powerful office in the Republic. Should be a very powerful office. Let's not make this law, because we perceive, we have this perception that somebody else is in power. Make this law, put in yourself in it. It might be you tomorrow. APC is certainly going to come to power. Another political party is going to come to power. SFP is going to come to power. It is for all of us. At some point. NGC will come to power. UNDP will come to power. It is for all of us. Of UDP. You might have PNP. Any political party has the potential to win power. As a nation, we should make the president very, very powerful. Because it is the president that must take critical decisions. Not take along with the kind of perception to say, oh, it's because we are not in power, we have to limit the authority of the president. No. We are not making this law for any political party. We are making this law for any president that will belong to any political party. We have flag bearers all over the place. They are flag bearers because they have this belief that they will win elections and become president. They too will not support a thing where you seek to reduce the power of His Excellency the President. I will not sit here as speaker to allow the position of the president to be watered down. It's a very serious position. Somebody has to be in charge of the nation. Somebody has to be in charge. Somebody has to have supreme executive authority. We cannot create a lame dog president. We cannot create a lame dog president where if he needs to do anything, he has to consult Mr. A, consult Mr. B, or he has to take permission from there. No. We cannot create that kind of president. Yes, leader of the opposition.
Yes, Mr. Speaker, I agree with you. I agree with you on this. Mr. Speaker, I agree with you on this because we don't make laws that violate the president's authority. That is why we are saying, according to what he has just read, it means the president will be bound to appoint him according to the strength of parliament. You know, the representation should reflect the parliamentary strength. And we are saying that
the use of the word may is discretionary. It's may,
yes,
not shall.
Yes, let me answer. Mr. Speaker, there are not, for example, the current configuration of this parliament shows that there are only two political parties in parliament. It means if this law was active, it means the president was just going to consider two political parties and leave all the other political parties. So we are saying if there is regional awareness in that very law, let us stop it at that. Let us not bring it to parliament. Because we'll be limiting the powers of the president to appoint.
The mention of parliament, if I understand what he was trying to say, the mention of parliament is just one of the options.
So
just one of the options, not the entire option.
No, if you read what he says, it's a mandatory option among the other options.
Read that one again.
If there was all...
Hold on, read that one again.
Mr. Speaker, the proposal reads as an appointing ministers and deputy ministers. Now, of course, we move to section 61. That changes. The president may consider as far as practicable.
Yes.
A, the political diversity of parliament, regional, etc.
That's one option.
But, Mr. Chairman,
that's one option.
Mr. Chairman, honorable members, we will define with removing A and keeping, and then the number needs to be in legal appointments. Then of course we will agree that this moves to section 61 to cover other appointments, basically in the constitution of the government. But then to now read as, whether they consider as practicable, the regional and district balance of the republic, gender equity, we will want to keep that in there. And then inclusion of minority groups should not be those three considerations. Thank you.
So are we okay with that now?
Mr. Chairman.
Yes, Honorable Tambakeli.
Yeah, Mr. Chairman, I have a question on the utility of introducing such an uncertainty. Mr. Chairman, let me read for you what 59 provides. It says,
we are now dealing with 61,
yes,
not 59.
Yeah, but it's on that. The same illogicality
We have moved away from 59. We are now dealing with 61.
I understand that. Yes. But Mr. Speaker, the President, under the President's Constitution, has the discretion. It may such a minister. Any president with a modicum of common sense would know that after election, he would want to constitute a candidate that represents every part of the country without anybody telling him. Because it's political strength. Depend on that. If the people of Kano vote for a president, he will know that you have to have a minister from Kano. If the people of Kabbalah, do we need to put this in a constitution, clutter an important document like this?
This is a document of national unity. We are trying to create a document of national unity.
And then give political
so that is why that one is very relevant.
So
that's why it's relevant.
So political competition is really what this is intended to keep. Party competition.
Tamba Kelly, where are you taking that argument?
I'm taking it to Nigeria. You understand? The point I'm making, our constitution is based on the ability of individuals to organize themselves into political parties and compete for political power.
So how do you kill political competition by that provision?
By poaching, because this is really what they're saying. Go to the other side and poach.
And you think you don't have members of different political parties in the regions? Don't you have APC people in the other regions or SLP people in other regions?
It's okay, Mr. Chairman.
So please, Honorable Tamba Kelly, I think you are over-sophisticated for this. Yes, we proceed. Yes, are we done with that? I think this one is contention. Also, we are done. Also, yes, Honorable.
One more time for us.
One more.
Rendition. Let me read it.
The rendition. Yes. Mr. Minister, can you do that now?
It's just the opening paragraph.
Mr. Speaker, honorable members, noting that this now moves under section 61. Section 61 reads, subject to the provisions of this constitution or of any act of parliament, the president may constitute offices for Sierra Leone, make appointments to any such office, interminate any such appointment. We will now move what originally read as in appointing ministers and deputy ministers will now be making appointments under this section. The president may give consideration as far as practicable to A, the regional and district balance of the republic, B, gender equity in line with section 35, whichever the provision section number 2, just gender equity. Okay, gender equity. So it's A, regional and district balance of the republic, B, gender equity, C, inclusion of minority groups.
That's so powerful, eh? Very powerful. My AG, you have made my day. That's so powerful. Yes. This is my best provision. Very okay. Not so AG. Yes, so we go back to page 14 also.
Yes.
Page 14.
Page 14, Mr. Chairman.
Yes. Yes, Honorable T.
So I raised an issue before you adjourned. I just want to know whether it was accepted or not. I only had Honorable Deva say RP and then you adjourned.
Which one?
The city. So it had to do with deleting subsection 8 of section 54. On page 13.
Okay. What is that?
So it was saying delete subsection 8 of 54.
That is clause 11.
Clause 11.
Clause 11.
We delete the entirety of clause 11?
No.
In clause 11, in the two paragraphs, we only deleted the word president because it was dealing with the vice president, so we deleted president because that was what was done. So
what do you suggest?
So in this one, it says you repeal and you replace the subsection. And when you look at the Constitution, 54.8, 54.8 is dealing with other conditions that will lead to the removal of the vice president. that are mentioned in section 50 and 51. For instance, insanity of mind, physical health, and 51, which deals with misconduct. So if you delete subsection 58, if you delete subsection 8 of 54, then you say whether the vice president is mad, is physically incapable, or he's conducted himself in an improper way, he still continues to remain.
No, that's not the impression.
No, well, let's read it.
No,
okay, hold on, Mr. Chairman.
There is a proviso there that talks about the application of 50 and 51. Just after.
No, okay. Okay, Mr. Chairman.
Yes.
Please be patient with me.
I'm patient.
Okay. So now, 11 says, subsection 8 of section 54. I want to refer you to section 58 of 54. Subsection 8 of 54. Let's look at the Constitution, sir.
Yes.
It's amended. Yes.
Hold on. Oh, yeah. Hold on.
I mean, stop.
Yes.
Mr. Speaker, you were classmates.
Yes.
Remember that too.
Yes.
I don't just jump up, eh?
Yes. Yes, you are right.
Thank you.
You are right.
So it should not be.
You were almost defeated. Thank you for coming back. Thank you for being very stubborn.
Well, it's been the same way for me.
So yes, AG.
So instead of repealing it, amend it.
Yes. Mr. Chairman.
Do a rendition.
Yes, we will do a rendition of that. We will still propose that we keep the proposed the revised section 8, but then as an addition. So we keep, yes, so that is section 8, and the current in the current section 54 will move to section 9. Yes. It will be a proposal for that. The new section 8 comes before the current section 8 starts. Yeah. But anyways, the broader principle is we keep the current section 8, but then we include the proposed section 8 as an addition, and then thank you, Mr. Speaker.
Yes, I think that's great. Page 14.
Page 14, Mr. Chairman. Page 14, talking about the amendment of 76(1)A. But here, paying close attention to the ministers. From the debate, there were discussions, and I raised that up. If the diasporans can make their investment here, they should not be limited to executive and legislative participation.
Hold on, honorable members, can I appeal to you? My appeal is that we allow diasporans, but with certain conditions. We allow them. This is a passionate appeal from Mr. Speaker, that we allow them, but we put certain conditions under which they can contest.
Mr. Speaker.
Yes.
I want to join you in this. These are brothers and sisters. Some of them have even contributed to the development of this country.
Yes.
And some of us who are here.
Yes.
So I'm also sharing the same opinion that I asked.
Please allow me to appeal. Please allow me to appeal. And I'm sure the leader of government business is 100% in support.
Sure.
Yes, leader of government business.
Mr. Leader, just 1 minute. I don't only want us to limit their participation of being ministers of government.
Yes.
I want us to extend it similarly to becoming members of parliament as well.
Yes, the leader of government business.
Mr. Chairman, thank you for opening our eyes for a sensitive issue of set nature. In the debate, some of us did not mention 76, the debate, to see how members started. But some members did talk about 76. So what you have done as a presiding officer, you have made a plea to all of us to consider looking at the model. Things have changed, transformation, contributions to Sierra Leone after the interregnum, so many things have changed. So for me, I am positively supporting it with some caveats. The caveats will come, and we accept what are we going to do the amendment.
So can we agree on the conditions?
Yeah, we are not coming. He will lead us. The minister has some, he will prepare.
Yes.
But let me make my first three submissions. Anybody that has to do with the president, that's why it's a bar. The president, the vice president, and those who are going to seemingly to be seen acting in the capacity of the president when the president is not around, or the vice president, the speaker, the chief justice, and even sometimes by extension the deputy speaker can be involved. So we are going to put a ring around it, such a way that we protect the sanctity of the presidency. Or we come more, AG will present. I don't give you that one as well acceptance from the first four. That is what. The others will come from the other categories. I don't know where AG is going. I
want to put this lady.
I want the AG to sit
in the firing line.
Mr. Chairman, yes. You know, when why did you want to step out? Maybe it's a kind of picture. Can you go down?
Is that so?
No, that's good.
Is that so?
Oh, it is something with the
Don't worry. I know she has enough capacity, but she has enough capacity, but we want you to be there. Yes, Mr. AG, can you tell us the conditions?
Thank you.
We agree.
Thank you, Mr. Chairman. I'm glad you did note that she has enough capacity. She doesn't understand in the line of fire. Sometimes she is fire herself. But yes, Mr. Chairman, honorable members, we're pleased that this honorable House agrees that this provision be included in the Constitution. And it will be a suggestion that yes, it will be the person who is a Sierra Leonean by birth, but holds the citizenship of another country, shall not be eligible for election as a member of parliament unless prior to the election they paid local taxes to a community in Sierra Leone for a period of 5 years, and that such person has been physically resident, in Sierra Leone for a period of not less than 24 months. We will add
Hold on. I've not opened this matter. I've not opened this for debate. Please sit down. Sit down. Mr. Minister.
Yes.
Read out the conditions.
Yes, Mr. Speaker, honorable members, yes, 24 months physical residence requirement. We want to propose a third requirement, noting that we want, in addition to what the leader of the opposition said about contributions to the country, we also want, really strong ties that connect people to this country, including indicating an intention to, invest in retirement in this country. And so we will propose that a third condition be listed as for a period not less than 5 years that individual has subscribed to the country's National Social Security Scheme. That's it. And then we'll include additional language, as the leader of the opposition has said, that such a person will not be qualified to hold the position of President, Vice President, Speaker of Parliament, Chief Justice, and the position of Deputy Speaker. This will be our proposal, Mr. Speaker.
Yes,
Mr. Chairman, considering the sensitive nature of this constitution we are amending in this sixth parliament, I want to agree to your plea to this house, but I am first of all requesting that we add the bank government. He's the custodian of our own.
Okay, yes, honorable.
Mr. Chairman, I want to thank the AG for the conditions. We've agreed on the what, but I think we have to be very clear on the how. There are some additional safeguards I want to propose as well. And let's also bear in mind that whatever changes we are going to make now, amendments, they are going to affect possibly Section 41, they will affect Section 54, qualifications, Section 56 to 60, 75 to 77, and also the test schedule, the oath. Now, the additional safeguards I'm going to bring up. First of all, they must disclose all foreign citizenship. It's very important. Yes, you are a citizen, but you must disclose that. Then, you also have to disclose any foreign public office or allegiance. I hope I'm not shouting. The problem here is let's don't get into it. I start sensing that already. We talk about significant foreign or financial interest. Now the question, I'm worried. What about the position of Chief Immigration Officer? The Chief of Defense Staff? The Inspector General of Police? In as much as we are ready to take this bold step, but let's try to find it. It's possible. It's doable. You understand? So let's look at it. These are the safeguards. The 24 months, maybe even preceding the election year. So it's about how do we track some of these things.
Honorable. Order. Proceed.
It's about the tracking. So again, we have to think deep. That's why I cited the sections that will be affected. We'll come back to this condition. But I rest my case for now. There are many more that will come on as far as it is. So thank you very much. No, you don't want me to stop? Reduce your height.
After Honorable Bokari, Honorable Ekeke.
Thank you, Mr.
Then I will allow Honorable what's the name? Kemokai, yes, Kemokai. All of you wait, all of you. Yes, Honorable Bokari.
Thank you, Mr. Chairman. Mr. Chairman, honorable members, I don't think we are asked to having our brothers coming back home to contribute to national development or state building. But what some of us want to protect is the national security of our state and the interests of our state. I guess a good number of us here have the opportunity to
also go and stay abroad or overseas, but we made the decision to stay back and make our own little contribution to national development. So in as much as we'll be having our brothers and sisters coming back to make their own little contribution within the governance trajectory of our nation, I had the opportunity of having a discussion with the chairman of the legislative committee, and I think he has a couple of those critical governance positions we agreed on that we should put forward. And I just want to make addition to the list they have just called out. My brother over there was talking about our finance, our monies, the bank governor. In addition to that, I think the office of the Anti-Corruption Commissioner, the Auditor General, the Deputy Minister of Defense. Yes, the Commissioner General, the Deputy Minister of Defense, and Minister of General Affairs. Those are key security sectors when it comes to protecting our national interests. Thank you, Mr. Chairman.
Honorable APK.
Mr. Chairman, the Honorable APK and the Chief Whip. Mr. Chairman, I think if we are making law, we must be open-minded about the law we make. We cannot stand here and say we are giving opportunities to our brothers who contribute their monies unconditionally to political parties, who pays their air tickets, their airfare to come here and register and vote in our elections. And Mr. Chairman, let's not forget that the period between registration and voting, sometimes it's 6 months, sometimes it's 3 months. So they are required to come, buy air tickets, come register, they will stay for a few days, and they will go back to their country where they are staying, where they are working, and they will have to come back, buy another ticket to come and vote. Sometimes some of them even come during the campaign period. They will join us to canvass. They do that because they are patriotic. They do that because they believe that whatever citizenship that they may have acquired, they may have done that because of greener pasture and because they want to contribute to the financial state of their country. So, Mr. Chairman, if you are saying you are giving them opportunity to be parliamentarian, what position is more sensitive than being parliamentarian? You have total opportunity to see the entire state in its bare form. You examine the budget, you perform oversight, you do an appropriation committee. So if you say you are going to be member of parliament, you would have the power to rise to the position of leader of government business, or leader of opposition, or chairman of the public account committee. Mr. Chairman, even if you are not chairman of PAC because they say deputy speaker is tired, you are chairman of transparency. You cannot give them, like you say in a local balance, you hold the hope, you give the cow, you hold the cow. Please, if we are tying it to the presidency, the vice presidency, the chief justice, attorney general, let us allow them to come and not suffocate them with an opportunity as if they are coming to bed. They are ceremonials. These are our brothers and sisters. You see, we have lived in apprehension for too long, Mr. Chairman.
Why are we even disowning them?
Why are we disowning them? That's the point.
Why are we even disowning them?
Why? These are our brothers. They've gone out there. They can never be more patriotic to this country than any other country. So my submission is, let us limit the restriction and let us keep our minds open. 76-1 has been in our constitution for the longest time, not until the revered lawyer that is Gabriel raised it. But all of those people have been serving during that period when 76-1 was in our constitution and they hold dual citizenship. They have never tried to undermine the state. They have never created a situation to undermine the state. So let us be open and let us pass the law so that it will benefit our brothers and our compatriots.
Mr. Chairman, I listened to the Deputy Speaker who spoke eloquently and even made points for our brothers and sisters staying overseas. I don't want to repeat myself. I don't want to say thanks to the AG for bringing us to speed. We had this same position in the 5th Parliament. We had so many discussions around it. We were unable to do the amendment based on certain reasons. Today we have the opportunity to read the amendment. Definitely there are going to be caveats, but we want to do it with consensus maybe with the paramount chiefs and my colleagues on the other side. So we can agree on certain caveats, but it's a caveat that makes sense to everybody that is practicable in living overseas. In overseas, you can have dual citizenship because if you follow the phrase, supporting while proposing for us to do the amendment, they said in clause 14A, Roman 2, a citizen of a country other than Sierra Leone, having become set a citizen voluntarily or in order a declaration of allegiance to such country. We are mindful of that statement, but they are patriotic in Serbia, as you said, we don't go over that. There are countries like in America, as long as we have dual citizenship, we cannot be part of the police force. So we cannot say economic police force, for example, the General of Police. We are talking about, like I said, for the Attorney General, there is another case, because Attorney General, the position of it, even in the Constitution, is secret. That's why the AG, when appointed, doesn't come to Parliament for approval. The nature of that office is very critical. So it's a matter of just all of us to give the responsibility to the chairman of the State Committee to put something in the caveat that we can agree. And as we talk about ordinary residents, we have taxes, local tax, NACIT, all of these things we can work on. So that it just can serve as what we have in best practice. That one could be a way to appease certain people. I know my colleagues, for this time, all of us will be apprehensive about what will happen to our this, to that. But we are doing it in the true sense of the sweariness we have. The loving spirit we have to approach. So the spirit is this, that let us do this amendment, that we accommodate our brothers. During the interregnum, all of us, to be honest, we are yearning to go overseas. And if overseas, as Honorable Uyata said, we are given the opportunity to naturalize, thinking about the time we were, the difficulty during the interregnum, particularly about the maladministration for over 20-something years before the war. All of these things, so we need to have to rethink, to reset our memories, to look at where we can go. It is not a pro bono business. We have accepted. That's why I said, let me say thanks to the minister. And your appeal you made is very clear. So as we just agree to accept the amendment with caveats, let us do the caveats in the world. Once we look at what our policies are coming, by the time we reach here, we now have a discussion around the caveats that we reach around the 76 one. So I advise Mr. Speaker that going to over and over, it doesn't make sense to all of us. Let us agree, we move on, we come to it, having a caveat that will be a consensus caveat.
Okay, after Honorable AKK, then I will listen to you. Can you do something beautiful? Let's work on something beautiful.
Mr. Speaker, yes. Honorable members, I supported this bill and this part of the clause, and I've always at every level. I start with an appeal. Since this voting will be done under secret ballot, I appeal to my colleague MPs that for the sake of the progress of our nation, this particular one that has to do with Tusin, let us vote for it and don't vote against it. But Mr. Speaker, my worry is when we put all the caveats, there is one we've not mentioned. What if the person has committed a crime from the country where he's coming from? Maybe rape and is being deported. Do we have a situation in the law, Mr. AG, that where we examine the criminal record of the person, where he's coming from before allowing him to a kind of background check? No, I'm talking about being a member of parliament. You don't go to appointment committee to be a member of parliament. The police clearance is for internally in Sierra Leone. Can we listen to ourselves?
You see, Honorable AKK, you don't even need to worry yourself about that. The opponent will bring forth all of those.
No, Mr. Speaker. Why do you want that to be?
Opponents are very powerful.
Mr. Speaker, you can
I know what you're saying, Mr.
You can bring it up, but if there is no
Thank you, Mr. Speaker.
There will not be a caveat to that effect.
Thank you, Mr. Speaker, honorable members. I support caveats, just not to extend them so much. I'd like to provide some context with your dear Mr. Speaker. First, to the point raised by the honorable member, we have already proposed language in this bill to disqualify persons.
Mr. Chairman, point of order.
Yes, hold on.
You see,
hold on, Mr.
First, in every provision, sorry sir, if you want to build a house, you have to get a very good foundation. If you want to be in the world, you don't give the bricks the appropriate time to heal, you have a collapse in the construction. You don't put the appropriate iron rod like the measurement, you have collapse. So we have laid the foundation. And if you look at page 15 of the proposed bill, everything that my colleague on the other side has proposed is there. So what you are saying, I said, let us come to putting up in place caveats. By consensus, reaching out to the other side, the paramount chief will have a document that will be accepted by all. But if you start to address it in piecemeal, I'm afraid, police on this other side, police on the other side, individual feelings. Let us take a break. We have something around it. We present it to all the groups, and we come here to agree. The consensus we need to have, we protect the interests of our states. That's why he has proposed. Already it is in the bill, talking about if you are a criminal, you are this. We are a nation of goodwill.
I agree.
Thank you.
I agree, leader of government units. You know, the point is that we have all agreed in principle. All what we are looking at are the necessary conditions. And that's all the more reason why I told the minister to address us on some of these issues. Yeah. Because I think, Mr. Minister, hold on, the leader of the opposition.
Yes, it's clear. They will all be guided by the same legislation.
Yes.
When we say you must not have criminal records, it will cover everybody. Regardless of where you come from.
Everybody.
You know, the vetting process.
In fact, the conditions for becoming a member of parliament will apply.
Yes, exactly.
All the relevant conditions will apply.
And just as the Deputy Speaker was saying, we should not be too restrictive over our brothers and sisters who are over there. We should not limit them. And one of the reasons for which he said Parliament is a critical arm of government. If you have allowed somebody to come to Parliament and make restrictions in other offices, that person will come to Parliament and change the law, change the restrictions that they have created. So it does not make any sense. So to me, I am going to advise that we have our own policies.
And let's not go with the idea that we are electing presidents who do not know what they are doing. Presidents know exactly what they do. So let's not underrate our presidents. You think a president is going to take somebody with some issues related to his personality, and that president appoints such a person to a sensitive office? No president is going to do that. So let's not underrate our presidents. Yes, Minister.
Thank you, Mr. Speaker, honorable members. Thank you, Leader of the Opposition. I think you addressed my concerns as well, and Leader of Government Duties to the point raised on criminal record. I will not go into that anymore, but I will just talk about the caveats, Mr. Speaker, honorable members. I agree with members of Parliament who have said we should not stretch this so much. We should not overstretch it. It will be the proposal of government that the restrictions be kept to the positions we have proposed, we have listed, those offices that are in line, for the presidency. Mr. Speaker, honorable members, let's deal with some realities. This country has been through crisis before. We pride ourselves in being a stable democracy. Doesn't mean that the door is completely closed on what will happen in this country anytime in the future. But when we had crisis before, we brought in a Nigerian as Chief of Defense Staff. When we embarked on a reform process before, we brought in a British national, Kit Bill, as Inspector General of Police. But the examples go beyond Sierra Leone. Even without crisis, there are times when a country will genuinely want to benefit from the expertise of some person holding another nationality. Examples abound across the globe. Mr. Speaker, honorable members, the current Prime Minister of Canada, who was Governor of the Bank of Canada in 2008, did exceptionally well. The United Kingdom, of all places, hired him as Governor of the Bank of England, a position he held from 2013. We have seen Tijani Thiam, an Ivorian, based on his expertise, what he did with Credit Suisse, hired to head the Kigali International Finance Center in Rwanda. But let's bring this home, Mr. Speaker, honorable members. We make a lot of reference to the former Attorney General Abdoulaye Conte, who we sometimes say the architect of the 1991 Constitution, and who sadly passed not too long ago. Noting that in Belize, he was Chief Justice for 10 years. So this is how other countries have benefited from persons who hold our own nationality. So restricting the space to all of these positions that have been proposed, we might be tying ourselves in ways that might affect us in the future if the need arises to look beyond persons carrying just the Sierra Leonean passport. So it will be a submission to this honorable House that, yes, this comes with a caveat, but such caveat be limited to the positions that we have proposed, and that they not be extended for reasons that I've mentioned and examples that I have provided, the restriction not be extended. In fact, another example, remember the former commissioner of the Metropolitan Police in London, who was moved to New York, and all of that. So, again, we have Sierra Leoneans providing expertise in different parts of the world, and those Sierra Leoneans, we have not even talked about foreign nationals, but those Sierra Leoneans who were born here, or those persons who are Sierra Leoneans by birth. I don't want my Koto, Dr. Mfa to come after me. But those Sierra Leoneans, those persons who are Sierra Leoneans by birth, but happen, for any reason whatsoever, to hold citizenship of another country, I agree with the chair of the legislative committee that those persons should disclose those other countries that they hold allegiance to, or that for positions to be held, we propose that they be limited to those that are in line with the presidency. That will be my submission, Mr. Speaker.
Yes, page 14.
Mr. Speaker, please, I want to call your attention to the time.
Okay.
I move as SO5 to suspend the business of the House of continue.
Any seconder? All those in favor say aye. Those against say nay. The ayes have it. Proceed. Page 14? 15. Yes.
Clause 14B2, which is at the top of page 15. 20, page 15. Yes, page 15. It begins from page 14.
Yes.
It says,
hold on. At this stage, I recognize the presence of Honorable Tondone, who is here with us. Yes, proceed. Page 14 to 15.
Yes, at the bottom of page 14. It says, the public officer who is 1. Employed or paid from the consolidated revenue fund. And I have problem with this woman too. See, at a level that requires him to clear his assets under the Anti-Corruption Act 2008 and shall not be eligible to contest an election under the Constitution unless he resigns from public office at least 6 months before the date of election.
Honorable members, how many months? How many months? You just tell us the months.
No, that's not my contention. My first contention is with the wording.
Yes.
It says at a level that requires him to declare his assets under the Anti-Corruption Act 2008. So it means the day Parliament changes the Anti-Corruption Act 2008 to any other area, then it will not be effective.
Mr. Minister. Mr. Minister, that's the crafty way of putting it.
Mr. Chairman.
Yes,
You don't want to. Yes, just shortly. I'm going to suggest that we revert back to how it was in the original. Because we just changed from 12 months to 6 months so that they have earlier opportunity.
Yes, leader of government business.
I think he has said the extent was very clear on that.
Yes. So we leave it like that?
Yes.
We leave it like that. Yes.
We are amending anti-corruption now. Several times.
Yes.
Overstating the law is like you are trying by extension altering it.
Mr. Minister, maintain the law as it is.
Yes.
Mr. Chairman, this parliament will be on record to note that if we are flexible, we have to be flexible right through. If we are flexible with our brothers outside, we have to be flexible with him.
There is no way you are going to win that. There is no way you are going to win that.
Mr. Chairman, you will be shocked if I move 46-1 and you will see the number of votes I will acquire.
Honorable members, don't waste my time. There is no way anybody is going to win that.
Mr. Chairman,
hold on, Mr. Minister.
My mother is serving in the armed forces, and my mother has served up until a period to defend this nation, the territorial integrity of this nation. And he wants to be a politician now. He's not carrying a position. Why should we wait for 12 months? Everyone may say why?
Mr. Minister, maintain the law as it is.
Mr. Speaker,
yes.
Just some brief comments on this. I think the reference to...
Somebody say it's because you have no more interest in parliament.
No, sir. You see, what I believe in my works, and I believe in the way I identify with people. And it doesn't matter, even if the length of time is 0. I have said it, and I am contesting, and people know I am contesting, whether at any level, I will still come back. Even my chairman is involved in
Mr. Speaker, honorable members, context matters. I take the comments made by the leader of the opposition about reference to the Anti-Corruption Act. We will include that as amended. For the rationale, Mr. Speaker, this Parliament amended the Anti-Corruption Act to require persons employed in the civil and public service below a particular grade to not have that obligation to disclose their assets. That also informed our thought process. But I like to give examples, Mr. Speaker, honorable members. Not so much for the soldier. Of course, I take that example as well for someone who has served. But I always like to give this example of a teacher or a health worker in Bikolo, or in Mongol, or in Kailam, someone who has served their community, and they carry the trust of that community. But of course, we know the conditions under which teachers in certain communities or in the country serve in this country, or health workers. But then, they are so respected, such persons are so respected in their communities, that these communities want to send them to Parliament to represent them. So what we're saying, Mr. Speaker, honorable members, with this provision, we're basically saying even someone at that level, a primary school teacher, who carries the trust of their community, and who that community wants to send to Parliament to represent them, we're saying that person at that level must resign and live in poverty for 12 months before they can come to Parliament. That will be, in my humble submission, absurd. I don't think that would have been the intent of the framers of this Constitution. And so it is our submission that such persons that work in the public and civil service below a particular grade be exempted from this clause. That is the position.
Okay, after leader, I will allow the leader of the opposition, then the chief whip. Yes, leader.
Mr. Chairman, this is a progressive parliament. It's a progressive parliament. If we are flexible enough to encourage our brothers and sisters who are still in diaspora to come and participate in the process, we should also be flexible enough for parties who are going to be part of it, who have contributed, they have worked, and we have persons who will retire, let's say 6 months, 8 months to election, who have served in civil service, the public service, 8 months to election, and we are saying that person should not be given the opportunity to Mr. Speaker, hold on, sir, let me just land. Mr. Chairman, hold on, let me land, please.
Hold on, give me 1 minute. You know what? All those who want the law to maintain the law as it is, stand up. No, hold on. All those who want the law maintained, the law that has to do with 12 months, just stand in your place, let me see. Those who want the law to continue as it is, they resign 12 months before election. Stand up, let me see. Stand up. 6 months.
Chairman, yes, speaking. Yes, for all you know, SO 46 makes provision for abstention. So I don't know about them. No, I am sure if we have a secret ballot, we will know whether or not you want to support me or you want to support us because we are together.
Chairman, everyone, they are wrong. If you
I don't need a test case for you to know that your argument is in futility. I don't need a test case for you to know that your argument is in futility. So instead of wasting time on this particular matter, let me go. Okay, I'll take a pin.
Let's take a pin on this because we will not have fun now. Mr. Chairman, this is very important.
Leader of the opposition, proceed.
Yes, Mr. Chair, this is very important. To me, I think it's very unfair. Are we together?
Yes, proceed.
Yes, to me, I think it is very unfair for public officers to be limited for protesting for members of cabinet also. I want us to cascade it a little further. There are public officials who are also contesting for flag bearership in their political party that are using public resources to campaign, to go to places. So also, if anybody wants to contest for flag bearer in his political party, must decide one
Mr. Chairman, the 1991 Constitution is clear over the use of state resources for political gains. That is why the one-year ban was made for civil servants and people working for government. And these are people who are under instruction. They are not necessarily heading the institutions and the resources. They don't have total control over resources. But what the leader is saying, we are talking about commissioners, we are talking about ministers, people who carry total responsibility, and they move place to place using their authorities to get their own individual desires for the president. Mr. Speaker, if we are dividing teachers who are paid 2,000 euros, if we are dividing ordinary civil
servants who have made 1,500,000, who do not have, they don't use fuel, they don't have government vehicles, they don't stay in government quarters. I think it is more fitting for the safeguard of state resources to export it to the residents. Undue advantage.
Yes, Mr. Chairman, Mr. Chairman, I think we are about to see the practice. Mr. Chairman, when we are doing constitution and we are proposing, the vote is simple majority. And I believe when you pose the question for the 1 year and 6 months, there was a vote. So if you come back to that one and stick a pin to me,
no, we're not sticking a pin, we're done with that.
Thank you. So which stance?
Mr. Chairman, no, there was no winning. No, there was no winning on the vote. Mr. Chairman, Mr. Chairman, Mr. Chairman, Mr. Chairman, Mr. Chairman, Mr. Chairman, in fact, the argument for protecting the use of state resources really supports the earlier position that persons working below a particular grade, who in fact will not have access to state resources beyond their salaries, be excluded from this. Mr. Minister, the judge has ruled, the president has ruled.
Mr. Minister, maintain the law as it is. Honorable members, at this stage, I recognize the presence of the chairman of the LCFDP. I also recognize the presence of the chairman of APC, Ambassador Usman Elbert. I recognize the presence of the Deputy Minister of Mines, who was the Secretary General of the LCFDP. I also recognize the presence of the Secretary General of APC, Mr. Lansan Abdullah. I recognize the presence of the principal executive advisor to His Excellency the President of Public Service, Dr. Emmanuel Gaiman. I also recognize the presence of the Deputy Mayor of Freetown, Mr. Kwekulis. I recognize the presence of a very powerful female former Member of Parliament who also doubles as the current advisor of His Excellency the President on parliamentary matters, Honorable Dr. Fatmata Hassan. I also recognize the presence of one of the key negotiators of the Agreement of National Unity and a very powerful member of the APC, Dr. Kefala Mara. I recognize the presence of Madam Haja Fatmata Kamara. Are you here? She is the Deputy National Women's Leader and Deputy Minister of Trade and Investment. I recognize the presence of Mr. Nabil Musa Kamara. Is he here? I recognize the presence of the press attaché to the High Commission, Israeli High Commission to the Gambia, Madam Marhawa. I Dr. Victor A.B. Davis. I also recognize the presence of Alhaji A.K. Sese. I recognize the presence of Mr. Harold Toure. I also recognize the presence of Mr. Ibrahim Sorisisi. Mr. Ibrahim Sorisisi is the Secretary General of APA. I recognize the presence of Mr. Simeon Bangura. I also recognize the presence of a very senior lawyer in this country, Mr. Adi Macaulay. I recognize the presence of the Chief Executive Officer of the Small and Medium Enterprises Development Authority, Mr. Shaka Samuelsano. I recognize the presence of a very strategic member of the APC who also doubles as a former minister in the APC government-led government, Mr. Balogun Kuruma. I also recognize the presence of Madam Mariam Malu Bangura. I recognize the presence of the former mayor of Freetown, Mr. Herbert John Williams.
Mr. Speaker.
Yes, Mr. Speaker. Yes.
Please, we have Madam Mariam Bangura Maramalu as the women's leader national of the APC.
I also recognize the presence of Mr. John Sese. Mr. John Sese is here. I recognize the presence of Mr. Mohamed Pope Kamara. I recognize the presence again of Honorable Aymara. I recognize the presence of Honorable Lahadi Aladi. I recognize the presence of Honorable Alusain Alukonte. I recognize the presence of Honorable Johnson. I recognize the presence of Mr. Daniel Mongo Kamara. Where is he gone? And I recognize the presence. Okay, we'll come to that later. We'll come to that later. Proceed. Yes, Mr. Minister.
Mr. Speaker, there was a proposal put forward by my leader that the minister had to respond to. And I second that, I echo my voice to it. Our argument basically is saying, because we want to minimize the use of state resources and create a level playing ground for ministers.
I intend to be flag bearer. Not just ministers, but intend to be flag bearer.
Yes.
We are saying, Mr. Speaker, if a teacher wants to be a member of parliament, he must resign 1 year.
Hold on. Let me recognize the presence of somebody who have been coming to this well that you do not know. Let me recognize him today for all of you to know. And he's been a lecturer in the law school for over 30 years. He's the lecturer of Honorable Givao, the lecturer of the AG, the lecturer of the Speaker, the lecturer of Honorable Daniel Kroma, the lecturer of Honorable Thibault, the lecturer of Tambakeli, Honorable Tambakeli. He's the lecturer of all of us. And he's Mr. Dadis in top. So if all of us make presentations of the law here, it was one of those that made all of us, all the lawyers here, without exception, all the lawyers here, all the lawyers. You had me yesterday one in Honorable Thibault when I told him your lecturer was the one who did the drafting and was there arguing. That's the lecturer who lectured all the lawyers you have seen here. The AG, the Speaker, Honorable Gaber, everybody here. So I particularly recognize his presence. You are heartily welcome, sir. Yes. Of course, you
in addition to that, following a very popular statement at the law school.
Yes.
Before white, he white.
So I also recognize the presence of a brother, Mr. Patrick Robin. I saw him at the back. Please stand up to be recognized. He's a brother. And he came here today. Of course, those who know him as Pirax. Oh, yes, thank you very much. Yes, Mr. Minister.
Yes, Mr. Speaker.
Yes,
I am of the firmest conviction that it is not fair for public officials to be subjected to the circumstances that ministers of government are not subjected to, especially when the AG said, that for grades lower, I agree with him, because teachers are paid very small salaries, so they cannot suffer that. But government ministers receive one of the highest salaries. So if a public officer should resign 12 months before contesting for a member of parliament position, a minister should resign 12 months before contesting for a president.
Honorable members, please listen to me. Let me address this point. Honorable members, to say that somebody is contesting for a particular position is a question of fact. It's a question of fact. You won't be able to prove that somebody is contesting for a particular position. There is no way any one of you can prove that a minister is contesting for a particular position. In fact, most of the time when ministers are ministers, they don't come out openly to campaign. They don't come out. You only see somebody posting their pictures, somebody posting that they are contesting. It's a question of fact.
Mr. Speaker, it's in support of this statement that you're making.
Yes.
Because I am not sure that there is any minister that is contesting. It shows that I am not malicious in suggesting this one. So if there is any minister who is being hypocritical, if there is any minister who is hiding his intention, then the law will hold him for
Let me hear you.
Mr. Chairman, honorable members, for you to participate in your internal politics doesn't guarantee you the automatic stance that you are a candidate. Our point here is you should not be a flag bearer. For you to participate for the position of flag bearer, doesn't guarantee you that you flag them. It's an internal party our political parties should be able to censor their candidates in making sure that the candidates fulfill all the criteria that we should fulfill based on the Constitution. So if the parties present candidates that are not fit for purpose, then you have an opportunity to protest. But for you to say you want to participate and you should resign and you apply to one the position, then that's
Sit down. Mr. AG, proceed. Let me hear you.
On this,
proceed. Yes. We're on page 15.
Mr. Chairman, on page 15.
Yes.
Mr. Chairman, 15-2.
Yes.
That for you to be qualified, you should not have been found guilty of certain offences.
Yes.
But at the same time, very clear that even when you are found guilty, if an appeal is pending, because there is an appeal, it does not serve as a disqualification. Mr. Chairman, I think...
Is that what you said?
Yes. When you come to... It says, a person shall not be qualified for election as a member of parliament if he has been convicted of any of the following offences and sentenced to imprisonment for a term not exceeding 12 months without the option of a fine, whether the conviction occurs in Sierra Leone or elsewhere, if the conduct would constitute an offence in Sierra Leone. And when it comes further, it says any other offence punishable by imprisonment for a term exceeding 12 or more, provided that a person shall not be regarded as disqualified until an appeal against the conviction or sentence has been determined or until the time for an appeal has expired. My point is, it means you remain convicted, even though convicted, but because you have an appeal, you are qualified to contest.
A convict is a convict.
A convict is a convict.
A convict is a convict.
So I am saying
even if you appeal, until the appeal is determined.
Yes.
So we don't leave it at that.
Yes.
Until the appeal is determined, or until you succeed at an appeal, you are still a convict.
Yes, Mr. Speaker. So we have to look at it to reflect that position that you have held. Not merely because an appeal is lodged, would you be qualified. Even if an appeal is lodged, until it is determined you remain a convict. But that's not what it is.
If the appeal is determined, you are a convict. So no, we have to. Yes, leader.
You are making a point that is already agreed by the proposal before us. And I don't know why you, if you read it, F, you are reading F. Any other offence punishable by imprisonment for a term exceeding 12 or more, provided that a person shall not be regarded as disqualified until an appeal against the convicted or sentenced has been determined, or until the time for an appeal has expired. Mr. Chairman, if a principle of natural justice applies here, normal situations where you think you have the right to appeal, even when you are convicted in the cases, said because the principle of natural justice is giving you the right to make another case or a submission. Our laws speak to the fact that you have to make an appeal. So if you are giving an appeal, the only thing that will be different from here is the issue of integrity issue. For elections, there has to be a lot of integrity because you are not to man the office of state. So while we can agree to make it very clear, instead of subjecting the natural, the normal circumstances, for election purposes, we can say, even if you are having an appeal, until the appeal is cleared or a court is giving a judgment against that.
Until the appeal is determined in your favor, you are a convict. And it will be outrageous for us to make a law to say that as long as you have an appeal, you cannot allow convicts.
Wait. So that's what I'm saying. No, this clause now, on his next sentence, he says you are not disqualified. So that's what I'm asking. Yes, look at it, let me read. Provided that, he said, any other offense punishable by imprisonment or by a term exceeding 12 or more. The next one, provided that a person shall not be regarded as disqualified until an appeal against the convict or sentence has been determined. Or until the time of an appeal has expired. So the principle of natural justice applies here. That's what I'm saying. So I'm saying now, for election, we can agree to say, no, this one, we are waiting for the final year of that. So, just like that election courts, because of the Public Elections Act, the elections courts is different from the other courts. They are trying to expedite the process so that we cannot interfere with the ruling. So for me, I think we have to look at it in terms of integrity issues for elections or individual, because you are going into an office if elected. But if you are talking about appeal, I fear this issue of criminal conviction upon you that be convicted and an appeal is a mixed feeling of our constituents. So we want to draw a clear line of sanity that no, this is not about principle of natural justice. It's about principle of decency and natural system. I am just thinking about it. But for me, sir, for me to place some of these things in the Constitution, I don't think it's the right place. These things should come in the Public Elections Act. Let's draw attention to the consequential amendment.
Mr. Minister,
it should not be in the Constitution. It should be in the Public Elections of 2022.
Mr. Minister, it is so outrageous to even begin to think about this in our Constitution. Yes. I don't see any rationale for this. If somebody is convicted, just imagine somebody is convicted of treason, of murder, or manslaughter, of rape, sexual penetration. And you want to even tolerate that kind of conversation?
Mr. Chairman,
you even want to tolerate that kind of conversation?
The reason why I drew my attention to this, in the Legal Practitioners Act, we have a similar clause, wherein if you are disbarred, the moment you lodge an appeal, that decision is a stay. The moment you lodge an appeal, so it's the same effect that this clause was about to have. Even when you are convicted, once you appeal, you start not to be disqualified. That's the effect that this has. So we have to delete it. Yes.
So, Mr. Chairman, the new the proposed Legal Practitioners Act actually addresses that.
Not the proposed one. I'm talking about the instant law, not the.
No, I'm saying we are dealing with it, but this should not really be. It should not be an appeal should not be a bar. It should not.
And the sad thing is that when you win your elections, and we start protecting you, we start invoking privileges. We say no, you cannot be taken to prison.
So, Mr. Chairman, let's remove it from the Constitution.
So when you win, it becomes complicated.
Mr. Chairman, I perfectly want to agree, as I said, honorable government points on the principle of natural justice. And my colleague now supported my position. But let me tell you, on the issue of the Sexual Offences Act, which I presented to Mr. Act, the Sexual Offences Act. There is an administrative aspect of that act, which I'm going to fulfill. This issue of sexual penetration. Our acts, we agree with the moral standard that we should pass this act on the pretext that we are going to have an administrative package to deal with this law decisively. That has to do with sexual penetration, the forensic testing. I went as far as the British Council to meet the High Commissioner. I made an appeal that we have done our best to pass this law. It was a really confrontation between us and the paramount chief.
and we made certain undertakings that have to do with that particular act. Let me tell you, we need to review that act in fact. So bringing sexual penetration here is a whole game. So for me, we want to make our elections credible and bring some decency. But constitutions are different from other acts. That the way you deal with constitutional amendment is different to the way you deal with the act of parliament. So let us agree, just take it. Since we are anticipating part 2 of the consequential amendments to this bill, let us just take it to the public elections after 2022.
Yes, Mr. Minister, I think that would be great.
Mr. Speaker, also on the same subject as Modiba just said, we should try to think about this in
on the same page?
Yes, elections-related offences. Elections.
Where is it? Oh, yes.
Yes, but yes. So we could amend the law.
If we are taking that off, it would also affect the extant law.
Yes.
And equally, I see they are proposing to delete paragraph H of the extant law. I don't know why.
Yes, Honorable.
You see, I don't know if we are doing this in tandem with the regulations. From section 143 right down to section 155 deals with elections offences and petitions. These are the serious matters. This act was debated for over 3-4 months. If we have just proposed again, talking about offences here, ignoring the extant law for elections, we are not really playing fairness to the law. Yeah. So what I've said, I just in line with what the leader of opposition said. We are over-legislating, and that is why we overlap with the law, and automatically we are altering the law. That's what Honorable Jawara have said. He has just said it. We are altering the law. It's very bad, and in the constitution, it is treasonable. Because it's an act of parliament, we are just over-legislating it. You can't do that.
Mr. Minister. Yes, hold on, let me hear from the Minister. Pardon me? Yes? You want to confirm? Okay, why is this conferring? Yes, let me hear you.
Yeah, and Mr. Speaker, when I look at C, under the offences that can prevent someone from contesting rape or sexual penetration, I have no problem with rape. But when I looked at the definition of sexual penetration under interpretation, then certain things are missing. I read the definition.
Under sexual
offences act.
Which interpretation? In this bill?
No, part 1 of Sexual Offences Act.
Yes, define that.
Yes.
Read that out.
Yes. It says sexual penetration means any act which causes a penetration to any extent of the vagina, anus, or mouth of a person by the penis or any other part of the body of another person or an object. There's something missing. Without the consent of that other person, is not there. Without the consent of that other person, is not in the definition. Yes, it's not there. So when you use it this way here, sexual penetration, it only becomes an offense if there's no consent. The definition.
There is a reason. Under the laws of Sierra Leone, you do not have a consent until you are 18 years old. Sexual penetration is for anybody less than 18 years. In fact, sexual penetration are the same. The only difference is the age. So you do not have right to consent being 18 years.
below the relevant age, the question of consent does not arise. There is no question of consent. Yes, yes, Honorable Yuki.
Mr. Speaker, thank you very much for the education. The truth is, in penetration, it's a child and the minor does not have consent. And because it's a minor, the education will not include the consent. If the child is 17 years, 11 months, the child is a minor. If she's the one who went into your room on the rescue, she has no consent. So stay away from kids, allow the kids to go to school.
Mr. Speaker, why are we only referring to minors? Even an adult.
That is rape.
That's about 18.
An adult is rape, it's not sexual penetration.
Because it's a rape or sexual penetration. Rape or sexual penetration.
Yes. Rape for big people. Sexual penetration for children.
Mr. Chairman, the penetration here is not the physical penetration of your penis into the body of a woman. It is the act done on a child is called penetration. Whereas rape is the act you do forcefully on a woman. So that's why the law is saying for rape, that is an adult. Here you talk about consent. If you look at the definition, in penetration there is nothing like consent because it's a minor. A minor does not have consent. Just as we ask you not to marry the kids below 18 years.
Yes, Honorable
In relation to my brother's submission, he said an adult cannot be penetrated. Let's say you use your hand to penetrate an adult.
Mr. Chairman, point of order 34. Mr. Chairman, point of order 34. You see, I just introduced a phrase, and you have now seen the way rambunctious we are. So, thinking about putting this in the constitution, it will cause the whole election system to go back. So what you are saying, we are not making these laws for elections to vilify anybody. We are doing it to safeguard our electoral process to be more credible. So bringing some of these things to the constitutional amendment, it's making us worrisome. Now, how can you legislate defining penetration, non-penetration, when we have it already enacted by this very parliament? How can we think that was deliberated, voted on, and passed by this house? Mr. Chairman, we should not put the law to make into question. If you seek for an amendment, we can bring it into court. Let's have it. Mr. Chairman, we should proceed.
Yes, Honorable Sama.
I wanted to suggest, in relation to the leader's submission, that we amend the Public Elections Act and expunge this from the proposal here before us.
Noted. Honorable Sama. Yes, Honorable Sama, proceed. Are you okay now?
I'm okay, Mr. Speaker.
Okay.
Okay, thank you.
Yes. Yes, honorable members, 15, 16, page 15, 16, page 16, yes.
Yes, thank you very much, Mr. Chair. I have a couple of concerns with regards 3B which talks about pardon. You know, 3 is actually talking about how disqualification ends. You know, we have just spoken about, the crimes or the issues that will occur that will disqualify anybody from protesting. And 3, on page 16, is actually talking about how the disqualification ends. I am very much comfortable with the 5 years rule, which means if you have been punished for 5 years, you cannot be punished twice. So that is a leeway for you to be reintegrated into the system. But the problem I have with 3B is with regards to pardon. You know, it doesn't mean if you have been pardoned, it doesn't mean you are not guilty of the crime. It means you have been convicted. It is either you are liable to be punished or you are undergoing punishment. Pardon comes out of clemency or out of subjective reasons. It is possible we all know yearly or as the case may be, the president decides to give clemency to certain people to be pardoned. But that doesn't mean that somebody is not guilty. So for me, if somebody has been found guilty for a very serious crime, let me say a felonious crime, and for some reason he's been pardoned, I see it as something very absurd for certain people to be permitted to compete with normal people. So I think we need to revisit this particular one, and it is either, if they have been pardoned, it is either we put another safeguard to say they need 2 years to be reintegrated. Because let's assume if somebody is found guilty for treason, and let's say for any reason there is a change of government, and the new government comes, and the new government decides to release certain people on pardon. Let's look at it, let's give the human face to it. Do you think certain people should be allowed, with that kind of thing, to compete with normal people who have tried to actually observe the protocols of the law? So I have a problem with it, and I think, in my own opinion, I am not against people being pardoned, but let us say, they need 2 years to be reintegrated. Because if somebody, let me take myself as an example, maybe not for me, that's not life. Let us say people have been convicted, and for some reason have been pardoned, and the community is not happy with me, and I am allowed on pardon. I need time to be reintegrated into my same community. I need time to rebrand myself. So if somebody like me comes up and just immediately they see me contesting again, that will undermine the full essence of the law. So that's my submission, Mr. Chairman.
Mr. Chairman, I see what you have submitted. As I said, when you are legislating, you don't make the crime lucrative. You make it punishable. And you cannot become a convict and you want to enjoy the comfort which have been convicted for. You are pardoned. Those who have completed their sentence can understand.
5 years after the conviction.
Yeah, that one is okay. But
pardon 5 years after.
No, they said yes, 5 years after.
Pardon.
Yes. I'm still saying this. What you are doing is to bring sanity into the electoral system. If you are pardoned, you can be pardoned after you have sentenced for 2 years and pardoned by the president. So you should not enjoy the comfort of you being pardoned to come and take office. No. It should not be like that. If you have completed your term, pardon is one comfort given to you. But the man served you cannot be punished twice for a single crime committed. That is the establishment. That is a provision. But where you have served your sentence, 5 years, I think it makes sense for you to be free and all that. But where you are pardoned, say they become sentenced for 5 years, and you are pardoned in the next 2 years that you have served. I don't think you should enjoy that comfort. Now, they have done it, they are happy to they review in court.
So, do we get rid of pardon?
Yes.
AG.
You get rid of pardon.
Pardon goes.
Yes.
We are still on page 16. Yes, Honorable Kemokai.
Yes, Mr. Chair. I particularly.
Yes, after Honorable Kemokai, Honorable Pai.
I have a concern regarding.
No, sorry.
Regarding
Honorable Pai.
On page 16.
Yes.
That says 5 years after the sentence has been completed. Somebody said the other day you cannot double punish a person. Somebody has completed his or her term, which means that has been settled, by the way. And you are also punishing the person. He or she has to wait.
Yes, you need 5 years to reintegrate.
Why do you need 5 years to reintegrate?
Yes,
I need a clarification.
It's a way of telling people that crime is not lucrative.
And there are crimes, by the way, a lot of politically motivated crimes, Mr. Chair.
No, don't claim that. Don't claim that.
So I'm not preempting Mr. Chair, but looking at circumstances.
No, you don't make laws that way. You don't make laws that way. Don't claim that. We discourage crime. It's a target.
All right, I'm not preempting Mr. Chair, but it's a concern that we have to take into account.
Yes. Are you done? Yes, Honorable Zombo. What's wrong with your mic? Give her the mobile mic. She said, everything is wrong with her mic.
Thank you, Mr. Chairman. I beg to differ from where my colleagues come from regarding a period within which we can pardon. Mr. Speaker, I want this House to know that a sexual offender always has the tendency to repeat an offense, a sexual offense. Research has proven whenever that sexual offender is exposed to a victim, even after 5 years, especially if that sexual offender is in a leadership position, a position of advantage, he or she will repeat the offense. So for sexual offenders, Mr. Speaker, there should be no pardon. If you have sexually offended a child or an adult in a foreign country and you are here,
we are deleted. That one is deleted already.
Yes. So, but for pardoning, I think, Mr. Speaker, we should not encourage any sexual offender to have a position.
Thank you. We are still on page 16, page 17.
Mr. Chairman, don't move.
Okay.
Don't move.
Okay, after the leader, honorable to go. Yes.
Mr. Chairman, we are reading these offences to entirely with the Constitution. You realize that if this one, without 5 years, should not stay, that whole section, that has to be pardon, completion of term, it has to do with the ground norm.
Yes.
Yeah. So we maintain the ground norm and we delete all of these provisions. When we go to
which other provisions?
The one that has to do with the 5 years after the sentence has been completed for 3 disqualification starting from 15 in fact. Yes,
all of them.
Yes. So we can deal with them decisively
in the
foreign election.
Okay, yes, I agree. Mr. Minister, not so?
Mr. Speaker, first is to note that I want to make some correction before I respond to
Do you agree with the leader?
Not quite, Mr. Speaker, respectfully. The point is, Mr. Speaker, honorable members, the Constitution itself already lists certain offences that will disqualify a person from running for president, for parliament. These include fraud and dishonesty, and then convicted by any court for any offense connected with the election of members of parliament. Mr. Speaker, honorable members, when we put these in our country's supreme law, we have elevated them to a certain level, possibly putting them above all the conducts listed in statute, which would disqualify persons from serving in this honorable house. And so it is actually our position that these offences listed, they have been deliberately listed because of the gravity that they carry. I agree with the Honourable Member, for example, on the offence of rape or sexual penetration, very serious offences. Of course, on murder and treason, murder, manslaughter, or treason, as additions to fraud, dishonesty, or corruption, and election-related offences. If it helps, the proposal dealing with any other offence punishable by imprisonment for a term exceeding 12 months, we can dispose of that if members of parliament so wish. But in terms of hierarchy of offences, to just limit what we put in the Constitution to fraud or dishonesty in election-related offences, will be putting them at a level higher than those in the statute. And to accept if it is the decision of this Honourable House that disqualifiers relating to convictions for criminal conduct be moved to the Public Elections Act as proposed for these other offences. But if we are to list these ones in the Constitution and then move those other ones to statute, we will be creating a hierarchy in offences which will qualify or disqualify certain persons from serving as members of parliament. That will be my submission. But whilst I have the right, Mr. Speaker, may I just make a correction on page 15, C. Page 15C reads in paragraph H by deletion of that paragraph. Paragraph H actually relates to being president, vice president, minister, deputy minister under this constitution, and then of course not being qualified to hold office, not being qualified for election as member of parliament. If we delete that, then it will mean ministers and others of president, vice president can run for parliament. What we actually intended to delete was E. Because he says if he's under a sentence of death imposed on him by any court, we recommend the deletion of this particular clause because this country, under the leadership of His Excellency the President, and of course, with the support of this Honourable House, death penalty is no longer a sentence in Sierra Leone, so we recommend that be deleted completely. That's 76(1)(e). So that is what we intended to delete when, by mistake, we said H.
Okay.
Thank you.
Mr. Chairman, I don't think we are against the ED proposing for the penalties for disqualification under making it very clear. He is trying to express, if you go to 76(2) and 3, 76(2) and 3, it makes provision for what he has also presented to us a proposal. 76(2), a person shall not be qualified for elections to the parliament if he is convicted by any court of any offence connected to the election of members of parliament. That is one. And he said he has elucidated on it and expanding on it, the paragraph in page 15, that has to be 2. If you go there, he stated it. And he now listed all the categories of offences that has to do with convict in line with that provision in the Constitution. But 2 is also informing 3. So we should not keep the E part of it. Now let me go to 2. To 3. Said provided, that is the extension of 2, provided that in any such case, the period of disqualification shall not exceed a period of 5 years from the date of the general election following the one for which he was disqualified. And now he is saying, and that same provision in 15, we have it is E. E is how to repeat E in this provision. Now 3, any person who is the holder of any office, the functions of which involve responsibility for or in connection with the conduct of
any election to Parliament or the compilation of any register of voters for the purposes of such an election shall not be qualified for election to members of Parliament, election to Parliament. Mr. Speaker, as I said, we see the nexus now. Two informal things. You cannot sustain so all of them you have to remove them. Now, how do you address them? Even if Public Elections Act, you dealt with them decisively. So if he wants to look at them in a manner that we want to really express the level of misconduct or total sexual penetration of this, it should not be in the Constitution. So we should delete all of what has to do with this section 2 and 3 in the bill to us, and we address them appropriately in line with the Public Elections Act 2022. We now seek for the amendment. He has also proposed to us a consequential amendment in part 2 of this bill. We are positively in line for it. But the danger, when I introduced the offenses, sexual offenses, when I talked about it, you had Mancuni's on the other side. And that's the same argument you had during the sexual offenses bill. And when we have challenged the paramount chiefs and other people in the chamber. So I'm submitting that he has made, there's a provision already in the Constitution. But to actually deal with it on by election process, let us deal with it in the Elections Act, the Election Act. So that gives us a lot of gravitas to bring out other things. Because when you talk about penetration, we now ask, how do you? Because you have to also make sure that the accused, you don't just accuse somebody, this has to do with human integrity. Election issues are very sensitive. You don't like your opponent to use it as a case against you. Because sexual penetration, you have to penetrate, you always end up without forensic testing and other things. As I speak that act, we have to get needs for review. So I'm pleading with him that we maintain the status quo we don't know, and we come now for the constitutional amendment, deal with the penalties heavily, and which will satisfy everybody. Thank you.
Yes, Mr. Minister, how do you see that reasoning?
That works for us, Mr. Speaker.
Thank you. Page 16, the remaining part of page 16, I'm seeing section 85 on page 16.
I think we agree on this. I think we agree that this one might stay provision and we had a solution by
16 and
by the
section 85 and 87 also.
Yes.
Mr. Minister.
Yes, Mr. Speaker.
So you want those deleted?
Yes, Mr. Speaker, yes, we want those deleted. That would be clause 15.
Yes, clause 15.
And clause 16.
And 16. Deleted.
And then before we get to clause 17,
hold on. Delete clause 15 and 16. Yes. Now on page 17, yes, we are now dealing with clause 16, 17, and 18.
Yes, Mr. Speaker, before we go to clause 17,
hold on, the reader is up. Yes.
Sorry.
Before page 17, sir. It's just a question on the example of the Constitution, 7614. 7614 on page 66. Are those laws? No. I'm proposing a further amendment, but it's just by way of question.
Yes.
If they are not in place, then we delete them.
Yes.
7614. Those laws mentioned there, like District Council Act, the Rural Act, I think the Local Government Act took care of most of those laws. But these are colonial laws. So I'm based on the Local Government Act, I believe most of these laws were being repealed. So I don't know if it is still in place. Section 7614.
Yes. Thank you, Honourable Member, Mr. Speaker, Honourable Member, and that is why you will see that in page same section, page 16.
Hold on. I recognize the presence of Honourable Chairman of Najuba. presence of Honorable Sama Sadi. I recognize the presence of the Mayor of Freetown. And I recognize the presence of Madam Sally Adams. Thank you very much. Proceed, Mr. Minister.
Thank you, Mr. Speaker. We note that the various statutes referenced in this subsection were repealed by the Local Government Act of 2004. And so that is why on page 16, we have now said that we have now proposed that subsection 5 reads for coherence to actually list the various titles or entities, and then of course in connection with the act. So that is why you will see that 4 says the person shall not be qualified for election as a member of parliament and a regular B, reason only that he holds the office of a member of chief of council, member of local courts, a member of any body corporate established by or under any of the following laws. That is to say, we have the various statutes. So now we have said A, chiefdom council, B, a local court, and then C, a body corporate established under the Local Government Act of 2004. Because the Local Government Act has now repealed all of the various statutes referenced here. Mr. Speaker, so I hope that explains it. Mr. Speaker, honorable members, whilst I have the mic, I also will note an error here because this particular section has had to undergo a lot of renumbering. Of course, it will undergo additional renumbering. I'm noting the decision arrived at by this Honorable House moments ago, say to exclude certain proposals that have been listed here. But so whilst 3 became 4, 4 became 5, 5, subsection 5 was mistakenly left out because subsection 5 will now be set to subsection 6.
Mr. Chairman.
Yes.
What did you just say? I agree. But by retaining this section here means that the Local Government Act will be found to be inconsistent. That particular provision will be found to be inconsistent with the Constitution. But the Constitution still retains those statutes. So it will be found to be inconsistent. So for consistency and to avoid that inconsistency with the statute, it's good that we delete it here. When it cannot retain those laws, while the Local Government Act that is lower, that is just a statute, delete them, for the Constitution still retain them. So we can use this opportunity to delete subsection 4 of section 6.
Yes, Honorable Member. So that will lead a new subsection 5.
Yes, a new subsection 5.
I think if you go to this 4 itself, I will just have some discussion because these areas are very sensitive. Because we have to do as we did for, I was making reference to the public elections. We have not drawn attention to the Local Government Act 2004. Just as we deleted the anti-corruption as we don't need it because of the year. And if we look at 4 in the Constitution, 76.4, what I think, and the appropriate to me, I think makes sense, is only local government has not mentioned 76.4. So we delete this and replace with a proper word that will capture local government. You don't need it in here. So what is a local government? That is what that honorable is saying. That this has maintained which are not being repealed. So there is inconsistency. So what we need to do now is to bring the local courts, local government, to replace it, repeal for and replace, incorporating this one with local government. Because even if we're talking about local government at 2024, it will be challenged, they will challenge it. When it comes to what about if you change the air about a new one? So we have to repeal this one and replace, incorporate the local government. That is why modification sort of. So let me say, let me come. You see, for what Honorable Nkrumah read, a body corporate established under the local government Act 2004, Act number 1 of 2004. What about 2024? 2022. Yeah. So we have to do some modification to restructure it instead of just taking this one on board. We don't put it here to become something anonymous. Very free. So we have to look at the act. Let me just answer. Without looking at the act, what Honorable Nkrumah said, we say how do we do modification for 76.4? It will appear so nice that we don't complicate ourselves with the local government act. Thank you.
Yes,
Thank you, Mr. Speaker. I just want to know that in complete agreement with the submission made by the leader of government business.
And Honorable Nkrumah.
And of course, the extension among the deputy leader of the opposition.
Okay. So we delete 85 and, clause 15 and 16. Right. We are now on page 17, clause 17, 18, 16, 17, and 18.
I was expecting the AG to, because everybody is saying this is a consultation that was done all over for our fixed election dates. I was expecting the AG to throw light on this, why we should not maintain it, and why we should delete it in the Public Elections Act. It is there already, but it is not going to be proper review of enactment. So I do need to care for money. Why do we need to ignore this fixed election date?
That is in clause 16.
Yes. No, 7. Yes, clause 16. Yeah, perfectly right.
Yes, Mr. Minister.
Mr. Speaker, honorable members, we have noted observations made previously of that to keep sections review of section 85 as well as section 87 in this bill will contradict the provisions in section 108 about a bill for an entrenched clause and a bill for a non-entrenched clause. And so we have agreed that procedurally we will not have entrenched clauses and non-entrenched clauses in the same bill. And noting that on the issue of fixed election dates, that will require an amendment to section 87 and section 87 as well as section 85 are both listed as entrenched clauses in our constitution, and so amendments to these particular provisions will not only require a vote in this honorable house but will also require a referendum. And so it is our submission that a separate bill.
So 16 goes.
Yes, dealing with entrenched clauses will come.
16 also goes. 17.
So 15 and 16 will go.
Yeah, Mr. Chairman, in the spirit of legislating, in the spirit for us to meet constitutions, I don't want us to take the wish of our people that because of we are taking out 85 and 87, which has tremendous effects on the lack of its election date in December. In my debate, I submitted to this House that subsidiary legislations must come in between. There are countries we have a fixed election date. The which our electoral system is very inconsistent. We fight, President announced this. We have not established to have fixed election dates. We know very well, we have all agreed that it is 85 that the Parliament dissolved by itself,
a constitutional provision, which is an interest provision, we are mindful. We are so mindful of the time limit that when you dissolve parliament, you have 30 days for 90 days. When you want to have fixed election, it is a very critical point that that to our election system.
Now, what is saying?
I want to learn so you can respond.
We cannot proceed.
You cannot proceed, but there must be a commitment that we, as parliament and this nation, if the wish of the people to have fixed election date, we should make a commitment to have a subsidiary election.
Appropriate document, an appropriate bill. That's what it says. You cannot come under this one.
So you make a commitment. That's what I want to get clear.
Oh, you want to get that commitment?
Commitment, because
yes, of course.
It's all about both sides.
You can make that commitment.
Yes, let's have that. It's about how do we deal with the fixed election date. And you made a commitment, but it was not clear because you cannot do anything now because you are taking away 87 and 85.
Well,
so
the commitment really will be neither here nor there.
Yes.
But for the sake of it, we'll listen to you.
It's just a commitment, yes.
Mr. Speaker.
Yes.
Before the minister, please.
Yes, Honorable.
It's a further suggestion supporting the leader of government business.
Yes.
We go to the clause 87, dissolution of parliament.
I noticed recently you always support the leader of government.
It's a Kenema thing. It's my set to borrow from pen.
It's a Kenema thing.
You know, I started putting in his head that he should come to parliament.
No, he knows what I'm asking. He knows what I'm saying. You support the leader of government. You know, I like seeing it like that. Proceed, Honorable Krumah.
In addition to what he said, section 87, dissolution of parliament, 90 days to election. If we are asking for permanent election date, there should not be, we don't need vacuum. So meaning the legislative arm of government has to continue existing instead of dissolving parliament in 90 days before election. You understand? That will easily attract section 29 of the Constitution. If there's any problem in this country, where the members of parliament are out there campaigning to come back to this place, there will be a problem. So I suggest to the general that members of parliament should remain in parliament on the after election. They are not coming here.
That's not practicable. That is not practicable. Yes. Now I know you want to remove that. You don't want civil servants to collect. But you want to stay here and be collecting until elections.
Yes, I want to assure you of cooperation on this side. And you are... all the time. Yes.
Yes, proceed on.
Yes, you will confirm that we have cooperated on this side since we began the process. And we want to jealously guide the process to ensure that we do not abrogate the Constitution in any way and to ensure that we do not go against the laws of this country. So wherever we need to amend an entrench clause, we should in no way circumvent the process. We should do due diligence by going to what the Constitution says, especially in 108 subsection 3 for entrench clause.
Wherever we are amending,
I am saying, whenever we are amending an entrench clause, we should pay due diligence to subsection 3 of section 108.
We are not amending any clause.
No, it's just an advice.
Yes, of course, we are not amending any clause. We are just fine tuning. So we have not amended any clause.
We are not.
You can only amend properly, so called, when the passes. Yes. That is when you amend. Yes.
Sorry, sir. We are not even making an attempt to amend 85 and 87. We are not even doing it. In fact, I said it would be an enactment in the Public Elections Act talking about fixed elections, which was inappropriate. Did not go through the proper processes of parliamentary enactment. So in fact, we have to delete it. That will come under consideration amendment. But let me state why I have been making my presentation, that the AG should clear that point. You understand? And we are not too far from making a position with what we have also had discussions from the Kawan, the Wati also did in July. So there is a constitutional provision to add the fears of control. We are trying to create a situation where we have to leave the consultations and the things that we have always said. This is the white paper, especially the Justice Kawan. But let me read 108. 108. So this guy is our fear. So we give the AG a free mind how to deal with this issue. The reason why we are full of air, Mr. Chairman, SO2 for those can't take what you want, we pull up. Say because of our section 85 and 87, we all the people of this country need to bit of explanation. And so they cannot be in doubt because this has to do with everyone. Yes, he's coming now. Now let me, after this provision, he will now come properly. It says subject 109 of the Constitution. Subject to the provisions of section 105, God know, of this Constitution, we are on any matter, whether arising out of this Constitution or otherwise, there is no provision expressed or by necessary implication of this Constitution which deals with a matter that has arising, like this one we have now. Parliament shall mandate by an act of Parliament not be inconsistent with any provision of this Constitution, provide for that matter to be dealt with. So, because it's a chairman, I deliberately, people are watching us. Under your administration, they are watching us. What we have spent money, taxpayers' money, from Mr. Choka, late of blessed memory, Justice Kawan, blessed memory. Because of two provisions, which we have not taken our time to give proper edification to our constituents, and we just want to take it out. It has to do with the inconsistency of our election system, based around election date announcing. As I said, proposed, and we agreed, and we also agreed, and we are not going to do anything inconsistent with the Constitution. That we should make a provision where we can sit and do an amendment that is not inconsistent with the Constitution, that can be dealt with as stated in Section 109 of the Constitution. So, in the light of that, I have approached it quietly that we cannot just come and remove it. Please say something as a commitment in dealing with it. In line with certain provision, we cannot take action today while we need deferment. But in the future, we have to deal with it. That's my submission, sir.
Yes, Mr. Minister.
Mr. Speaker, many thanks to the leader of government business for...
Honorable Abdullah, 1 minute, sir. Yeah. Proceed.
Yeah, thank you to the leader of government business for the submission. So, Mr. Speaker, honorable members, first, by putting it in this bill, that was part of government's commitments, but we have noted that even when we put it under an amendment to Section 43, which is not an entrenched clause in our Constitution, we note that by including it under Section 43, it will have implications for 87. And so it was a considered view that, yes, it be removed. But, Mr. Speaker, the government maintains the position that uncertainty when it comes to the date for elections does not help this country. The two processes that have informed the bill that you have before you today have both recommended that we have a fixed date for elections in this country. The Justice Edmund Kawan Constitutional Review Committee recommended that there should be a fixed date for elections in this country. And when we got together as part of the tripartite committee, it was also a recommendation that we made. And each time that recommendation has come up, government has accepted that recommendation to say that we should, or we must have a fixed date for elections. We don't want to be caught in a situation when at some point we have a power-thirsty president who decides that elections must only take place on their birthday or on their wedding anniversary. We don't want to be caught in that situation. We want predictability. We want this country to have a fixed date to say this is the date on which in each electoral cycle we will have elections. It helps for planning, both for citizens as well as for governments or the elections management bodies. And so this is to assure this honorable House that we will come back with another bill that proposes a fixed date for elections to be debated and hopefully approved by this honorable House and included in our country's constitution. So yes, the bill will be before this House with a proposal for a fixed date for elections etched in our national constitution. Thank you.
So clause 15 and 16 elected. Yes, Mr. Chairman. Yes. Yes, we are still on page 17. Clause 17 and then section 155 of the Constitution. You know, there is an insertion of a subsection of 4 after 3 in the Constitution. But I think this is not exhaustive. You know, hold on. The leader, can you move for 16 and 15 and 16 to be deleted? Hold on.
Mr. Chairman, I move that 16 and 15 and 16 to be deleted because it has to do with election commissions.
Any second? Any second?
I so second.
All those in favor say aye. Those against say nay. The ayes have it. Proceed, Your Honorable Abdullah. Proceed.
Yeah, just as I said, Mr. Chairman, the insertion of subsection 4 after 3, section 155, you see the police acting ultra-virus is not only limited to the 3. A is saying act in partisan manner, further any interest of political party, prejudice a political interest. Yes, but this one, yeah, we can understand. But also, they have acted on personal interest. We have seen or heard of others coming from above. You know, those are personal interests. So if you interest citizens to really say where a police force acts outside this thing, also not take into consideration personal interest.
Yes, Mr. Minister. That makes sense. I think that's fair. That makes sense. That makes sense, not so? Yes, leader.
Mr. Chairman, see, there are things we don't, when we are enacting our act of parliament, I've said several times, you don't do the administration of the law. That's why the law you give room for those who are interpreting law to do some law. You don't do it like two things, like it's straight against. For me, we have the military. Everybody needs a policeman. Everybody needs a policeman. And if we want to make sure there is immediate discipline in the police force that has to be elections, let us use their own terms, their own acts. But coming here to say, I've said we don't break law because we want to be malicious as against institutions in the world. They have the free mind that it's up to do discipline that should be apolitical. Let us expressly state that one in a particular provision that deals with a particular institution in specific. Mr. Chairman, can I do so? Chairman, you know that 55 is very clear. And I have seen.
Is it 55 or 155?
155, sorry. 155. You see, some people act in bad faith. Some will act in good faith. Everywhere in the world, you have a bad policeman and you have a good one. Everywhere in the world. In America, the stories are so much. The stories are so much. So, talking about parties, for goodness sake, when I was in the opposition, we went for a meeting with police at the headquarters. I was there, and I saw a policeman, the former president, and he was trying to cover it up in a meeting with Mr. Donokodo Benjamin, Tijansi, and also as director of admin. He's trying to cover the picture, and I said, but why they cover up? Now, President Nani, you have tried to display his badge. The thing that you cannot do is to put the badge of a political party. But you have tried to display the badge. We are pushing them to a point that at every point in time, every citizen, you have voted before becoming an SFPP and an RPC. So what you are saying, we should not subject them as if they are not professionals. Let us take them by their own terms. They know what forces. They should not be partisan, they should be political completely. When we came to the enactment, unfortunately, you are not here, you are in recess. My colleagues on the other side. They brought this idea of making the SSP, the special security, and they removed the police that they should not participate and the military. I challenge them that they should not ignore the police force and the military. Because already they are acting in that capacity. Why do you want to remove them when it comes to having somebody to be the DG for the SPSS? Because they want to give the power to a specific individual. It is a president who has the responsibility to appoint someone to be the DG for the SPSS. Mr. Chairman, I said they should remove it. Because what you are doing now, you have a special division. You have a special division in the police force that are already acting as state security to the president. They are the Lord. Because you want to create a special work patrol, make them more professional, that doesn't mean you have to remove the police and the military. I said, no, it's unacceptable. And we get to that one. We are coming to actually put in constitution to say, today I am in governance. The police force, they take instructions from the orders of above. It comes at the presidency. You have a function of honor. You give instructions to the police force or the military. Because you have a moral responsibility to protect the citizens of this country in terms of the sovereignty, in terms of their life and property. So, you are now saying, because police are always, when power is on the other side, they move to the other side. Like the military, because they are taking direct instructions from the orders from above. A function of honor. You want to tell me if I give Mr. Chairman, you want to say making Mr. A. This is the reason why if you are not wise enough as a president, when they call the name, we have Sisi. When we appointed the former CBS as Sisi, people say, Sisi, is that the minimum? They did not look at the ranking in the military. They didn't look at it. And I went to the president. I said, this issue of people talking about Sisi is a Timini, this SAP, what is happening? He said, and he removed a picture, a very good picture by his side. He said, the students here SO2. They were already by hand. He didn't give a position to this man. He didn't give another position to this man. He gave for retire all. And retiring them, it's a huge, it's a tax. You are putting your governance on the stage of a brick and a disaster. So, he said, in fact, Sisi was my boy when I was in Daru. He was a member of a platoon. He explained all the connections the general retired, the former CDS. So people don't know some of these things, but you try to describe them in the constitution. You should not be partisan. But the president is not elected by a political party. The president was elected by the political party.
So what are you talking about, partisan? These instructions to the IG or the CDS, that has to do with his office. So those instructions coming from a politician or the internal affairs minister trying to curb situations anywhere in this country. Why do you want to put partisan in the constitution? So for me, we did my humble submission. I really not looking at, I just want to be fair in mind. Let us look at the act of parliament that has to do with the military and the police force. Let us do the amendment, talking about professionalism instead of scrutinizing them because we are making laws in a more facetious manner, telling them, oh, police the election to waste the election come. That's why they behave. This is something all over the world. We should try to make sure our forces are very professional in terms of executing their duty. They can take instructions from politicians based on specific instructions. That is why, as a police officer or a military, when you are executing your job, you should know what is good and what is not right. You should be able to distinguish between the good, the bad, and the ugly before you act. So that we try to do this. I think, Mr. Chairman, Mr. Chairman, course of conduct, training, consistent training for our police force. Let me tell you the argument the AG was putting for when he put the IG as a way of disqualification. He said the days of Kitbil, the days of Prophet Zakaba, he brought in Kitbil. We brought in with Kitbil to take care of our security, our sovereignty. There was a problem with that. Yes, it's a challenge. So we have to manage that one during the interim. So we are a nation, we're thinking about what we have gone through, and how do we handle ourselves? These 2 months of suspicion, these 2 months of trying to water down some law authority of the state, because today Mr. A is in charge. For us, is the point. For me, let us maintain 155. And deal with their discipline in different acts of parliament.
Okay, you want us to maintain 155?
Yes. And deal with the issue of code, and deal with the issue of code.
You want us to delete this one?
Yes.
To delete 155?
Yes.
And 165?
Yes.
Yes, let me hear. Okay, let me show you. Your position. You hold a different view.
Yes.
Yes. Yes, do that.
I want to believe that the police should be non-partisan. I want to believe that never again we see this country where police will put on their trouser and a t-shirt of a political party. The police is not here to protect only members of a single political party. Police is painful because of the
What is the point? I will maintain this.
My point is
I will maintain this.
Why it is necessary in the Constitution in other legislation to be easily amended.
Okay, hold on. You are saying we maintain 155?
Yes.
And 165, no, 18 and 18.
I am saying that
Hold on. You are saying that we maintain clause 17 and 18 in this bill?
Yes.
Mr. Minister, what do you say?
Mr. Chairman.
Hold on. You know, so that we leave it. Yes.
It's something I want to make.
Mr. Chairman has not even allowed me to explain.
I thought probably you.
I wanted to explain.
Okay, explain.
Thank you, sir. Like I have said in other legislations, it will be easily amended. But we want to create a situation where it will be very difficult for this very clause to be amended. That you need 2/3 of members of parliament to amend it. We have all seen how police, there are some professional police officers. Some are professional. And even those who are professional have suffered because of their professionalism. You've seen a situation where a minister of government will just take a phone and call the police officer, give the police officer instruction. You see? So we want them to be totally insulated from our politics. Let them don't involve. They should act professionally. They are not here to only protect.
Honorable Mr. Minister, what have you got to say to this? Pardon me?
Mr. Chairman, before you do this, Mr. Chairman, I saw on CNN, when we lost the 2007 elections, saw police officers celebrate. If I allow Elias, BBC was on BBC. Ask more for now. I will wait. For you to bring this clause, you have to provide a wise with thought. And for me, I have the number here, even for simple majority. I just want us to be clear in mind. To be clear in mind of what to do. It doesn't mean that certain police officers, they have done the wrong thing, so we cannot come vehemently, vexatiously to try to amend the constitution because certain bad police officers. I am saying, in the interest of the state, looking at that institution, they already have course of conduct, go to their act. Maybe the minister can make reference to that. Their act, it's really clear. It's clear about discipline, both forces, be you the military, be you the police. But I'm saying, in 2007, Mr. Chairman, I saw it. It was on CNN when they announced the result. BBC, and you name them. Even 2009, when we came to government, we did not go after to say, you will not say you. What we need to express and take as a nation, how do we try to train our police officers to be professional? As I said, even advanced countries in the world, look at them. Today when you talk about demonstrations, a place that you say, oh, no violence, police no violence. Look what happened in the demonstration for Gaza. In the United Kingdom, where the trumpets and human rights issues right at the apex of our existence. Why have you seen those videos? Trashing people, throwing. I don't want to go into their jurisdiction. But what I'm saying, what we should do consistently is to train them and make them more professional. Be you SFPP, be you APC, we are using the police officers to our advantage. We have done it.
You see, both leaders, you are making my job very difficult. You are making my job very difficult. All what both of you are explaining, you want this clause maintained. You do not want this clause. All what you are saying just boils down to that. So I just wanted to stick a pin and we move on. When we come with that particular issue. All right, sir. But if you spend 2 hours just debating on an issue you are never going to agree on, that was the point. We stick a pin. Still using my pin.
Mr. Speaker, yes. Once we stick a pin on it, once we stick a pin on it. But from what my colleague has just said, that he was not too happy with the actions of the police in 2007. Okay.
Let me say it myself. In good faith and practice, we have used the police and the military in different circumstances. Being 2007, I just stated it was all over the media, over the international media, be it 2018, what I am saying.
Honorable member,
it's beyond state politics.
Honorable member, this sitting is stood down for 15 minutes.
We can go back.
Into the evening hours now. The sittings continued today after hours. Now the House is being stood down by the Speaker, having gone through some deliberations a few hours ago. Again, so MPs are looking deep across the aisle with different views springing up from their political ideologies and some from humanitarian views. Again, in the Well of Parliament this evening, we've seen where some certain clauses are being deleted and some other clauses are also being added to. The members of Parliament are deliberating intensely on some of these clauses. As you can see right now, most of the MPs have left their seats as some moment of recess is being given unto them. So keep viewers posted again. It's the third day that the Constitutional Amendment Bill is being debated in the world. On the first day last week, it lasted up to 1:45 a.m. Also, the last day, 3 days ago, the day before yesterday, it lasted up till 11:30, and today we are here again. It's not a sprint, it's a marathon. Mind you, the country goes back to look at its legal book. The legal Bible of the country is being revisited, having an alteration pursuant Section 108, subsection 1 of the 1991 Constitution. most of the contentious clause that MPs are looking at here this evening are those having to do with the PR system, which is being proposed to be the preferred electoral system, and that of the 55% threshold. And we've seen again where members of parliament are arguing across other provisions of the law. Members of parliament are also proposing that those in the diaspora will now have the opportunity to vote and be voted for. You know, the argument was one that has different views, but it seems as though the House was together on this one. Nonetheless, MPs are arguing and are adding that it is necessary to add certain cover to it, not to just leave it open, like for position of the president, that of the vice president, that of the speaker, the deputy speaker, and the AG, which are very crucial to the nation's running. So for such positions, you will not have a Tusima to come and run for such. But across the aisle, the argument have been that diasporas should be given the opportunity to be able to contest in elections. They should be given the opportunity to also come and vote. MPs across the aisle are of the opinion that they should be accorded that opportunity. Some are also of the views that it is to be very much, it is a process that has to be taken with care. And so with me right now, I have the chief whip in the Well of Parliament who will be talking to about the amendment process. Good evening and welcome to YPSA.
Yeah, good evening.
Honorable Dixon, the deliberation has been one of great national interest. And again, the opposition and the ruling bench have different views regarding certain clauses. But today we've seen where the deliberation come up more strong around giving opportunities to those in the diaspora to take part in elections. How welcome you think that will be for a nation's development?
Well, I think it's a welcome idea. That's more the reason you've seen that both sides of the aisle are supporting that particular clause. Because we have our brothers and sisters in the diaspora who comes for every elections, they come register and go back. When it's time to canvass, they come and canvass. So I believe we should give that opportunity also to continue participating in governance.
Thank you so much. I see the speaker is now already seated. Well, viewers, the speaker is back in. It was just a brief break and the sitting continues also. Well, the speaker is now seated in his seat and he's waiting for some of the MPs also to come in. As you can see, the majority and minority leader are outside, but yet the House is to resume its business again. The deputy speaker is also seated and the deputy majority leader and also the leaders on the opposition bench are seated again. Well, it's expected that today is not going to be as long as the other days, as we're already in page 17 of the bill. But what also people are speculating is that the voting will come strong today, as those clauses to which pins we are stick will come up for voting today. Well, still inside the well, we have the chairman of the SLPP party who is seated. He's been following very closely, and he has been here since day one. And also the chairman of the All People's Congress party also was in, and he just went out briefly And we see both of the political parties are being supported by their leadership, as their chairman and other members of the leadership are constantly in the well, viewing the process, giving encouragement, supporting their members of parliament, like giving them a tap on their back as they push forward the ideologies of the party. And also the galleries are also jam-packed and filled as members of the public, civil society members, diplomats are constantly around witnessing the deliberation, making their own presence known, also contributing to national development. Well, the sitting is yet to fully resume, but the speaker is seated in a seat and the debate is expected to continue soon. Again, apart from that having to do with members of the diaspora having to take part in elections as proposed by this bill, also the issue of having presidents making appointments that is cutting across region was one that was largely debated by MPs. As per the proposal, the Minister of Justice had wanted to add a clause dealing with saying the appointment should reflect political divide. However, the opposition was also kicking against such, saying it should not be tied to that. It should be open and it should have a regional representation instead of that having to do with political representation. The House agrees, and that clause was, that particular paragraph was removed. Speaker Thomas calls the House to order now, and the sitting resumes.
Yes, what's your position on this?
I wish to of government business.
You always have a leader of government business.
Yes, the leader of government business. That we keep this for the
Yes. So they are saying that we maintain this clause. You are saying that we delete it and maintain the one in the extra law. So that's the position. So we are sticking the pitch. Minister, we proceed later. Mr. Minister, you are in Parliament. Stop going across the aisle. Stop going across the aisle.
Apologies.
They should come and meet you.
So, Mr. Minister, what do you say on clause 17 and 18?
Mr. Minister is proposing we keep this law as
But the opposition is saying something else. So,
Mr. Minister, I think the opposition is on the same page.
No, we are not. Our position here is, since the leader of criminal business has given illustrative examples wherein both the military and police were being misused by politicians. No, that is what he said. Yes, so we are saying that to protect them and for them to be professional, this must be legislated on in the Constitution.
So we maintain this?
Yes.
Mr. Minister, so what do you say?
Mr. Speaker, honorable members, two proposals we have here, clause 17 and that of clause 18. Both fall under recommendation 78. 78, no. Let me see. Fall under recommendation.
Yes, proceed.
Mr. Speaker, apologies, I'm trying to reference the specific recommendation. Recommendation 74. of the tripartite report. It is one of those things that we discussed on the tripartite committee, and whilst in this constitutional provision, no penalties are listed, but it is a view. It was a view of the committee that it is important to set standards for our security forces in our country's national constitution. And then, of course, these can be explained in further detail with punishments in statute. We are currently reviewing the Police Act of 1964. It's a bill that will come before this House, and which, through that bill, we aim to transform our police from being a police force to a police service. So we'll flesh this out a bit more. It is something that the President himself is concerned about. Yes, we should maintain professional standards or set very high standards for our police and the military. So for us, we want to keep commitment to the tripartite recommendations, especially as we used to see on the tripartite committee. For some of these, you put them in the constitution, really no one will die. So it will be our recommendation that these proposals be included in both Section 155 and Section 165 of our Constitution.
Mr. Chairman. Yes, the chief.
Yeah, Mr. Chairman, before the break, the leader of government in the states stated its position very clear. And I have just heard the minister say that they are coming with the Police Act. In order for us not to be confused, can we leave this one at the instant law as it is and transfer it to the Police Act? Because mind you, when the Police Act comes eventually, we have to be looking at some of those clauses. And in event to place them in the Constitution now, when the Police Act comes, we might be tempted to change some other clauses in that Police Act. So I want to support the leader's position by leaving the Instant Act law as it is and put some of those laws in the Police Act.
Yes, leader.
Mr. Chairman, based on the presentation of the Attorney General Minister of Justice and in line with the tripartite recommendation, not taking everything. We also want to respect the decisions of forces who have made recommendations. In that way, therefore, I want to continue and support
Thank you very much. So, the leader of the opposition, the leader of government business has just conceded, so we proceed. Page 18.
Mr. Speaker, before we proceed, I'd also like to propose, I want to think ahead. It is my hope that when the police bill... Okay.
Exactly.
Yes, sir. Thank you, sir. Yes, sir. Yes, sir.
When the Police Act will go to amendment.
Leader?
Yes, sir.
The leaders.
Police. Leader. No. Mr. Minister, I have no problem with that. I just had it. Remain in that way in the Police Act, and we have it in the position. You know, because that the police
Too late. No, not 12 minutes. Then I didn't end. Not 12 minutes. So we can meet up and leave it at.
Yes, you know government business. Yes, what do you have to say about page 17 plus 17 and 18? Of course, I want emphasis.
Thank you.
I want to hear the speak for me.
Is that the way you shout? You speak for me. You brought your bill in this house and you spoke for me. You know, we're having the same agenda. What did you do? Mr. Chairman, you know, I said I want us as politicians to look at certain things that we do in the eyes of the public. I told the AG when you wanted to just amend to move on with 87, I said no. We have agreed in his own document in July 2025, and that people asked for the same date to be given for fixed election to avoid the inconsistency. I'm protected.
Yes, you are protected.
To see the face, to change the face of activities. So I accepted that we should not just throw the fixed election date by what we discussed. I said, okay, but we have to explain to the government. We have the tripartite recommendations. In fact, I recommended my colleague on the other side also. We have proclamation. And today, he is also telling me that no, this thing, we have used a police both sides, in good faith and in bad faith. That is through confession. That is how we should be doing. Let the public looking at us. So I'm considering based on the tripartite is a midway for us to commit. So Mr. Edi, I think I'm with you in this one again. I think I will put down my position. I will support the vision of the AG and also supported by the leader of the opposition. I will maintain the proposed clause.
Okay, thank you very much, Julian. Then, honorable members, I actually want us to stay put at this stage. But if you assure me that we won't be long, then we can just go through these ones. I don't think there are any. Are there contentions there?
Speaker, I will not assure you.
Mr. Chairman,
Mr. Chairman, I cannot assure you.
Mr. Chairman, taking a cue for my brother, considering the fact that when we started this process, nobody thought that 65 would be contentious. So for the purposes of what we have ahead, it is better that you listen to the leader of government business and then you allow us to go and do some small adjustments.
At this stage,
you allow us to go and more.
At this stage, I will urge the leader of government business to move an application for this particular process to be moved on to Monday.
Mr. Speaker, first, I have to talk with my colleague on the other side.
Yes, talk with
your colleague. There are some administrative arrangements that you have not won.
Yeah, of course.
You want to approve your table?
Yes, honorable members, be rest assured.
No, Mr. Speaker, hold on. Mr. Speaker, Mr. Chairman, hold on.
I need to say this.
brought a bag.
So, honorable members, by law, Friday will be the beginning of a new session. Friday. But I'm urging the leader of government business to move a motion for this process to be moved to Monday as if we are continuing in this session, so that we don't have to start everything all over again. So he can make that application, he can move that motion to be carried by the House. Then we'll just continue on Friday from where we stopped. On Monday, because on Friday we are starting a new session. But honorable members, be reminded that constitutional matters are serious matters. Constitutional matters are serious matters. I expect full attendance on Monday. And on Monday, I will be here not later than 10 a.m. in the morning. I urge every member of parliament to be present, especially you who are representing political parties. Don't think your leaders come here for fun. They come here to listen to you, to observe your participation. They are here for strategic reasons. They want to know how punctual you are, how regular you are in parliament, and the kind of contributions you are making. So I urge you to be here 10 a.m. prompt, and so 10 a.m. prompt on Monday.
Mr. Speaker.
On Monday, of course, the leader of government business. 1 minute. The leader of government business very soon will be making an application. But don't forget, we have state opening of parliament on Friday. State opening of parliament. Immediately after the adjournment, we have a 5 minutes meeting in committee room 1, just for 5 minutes, because we want to take you through the process so that you know exactly what the expectations will be on Friday when we come for state opening. Immediately after the sitting, please let's meet in committee room 1 for some serious conversation as members of parliament.
Chairman, can we ask me that to be short?
Pardon me?
Instead of going to committee room 1, we don't ask you that.
I think it's good that we stay.
No, we'll go to committee.
Let's go to committee room 1.
Yes. So that nobody will complain that parliament drives them.
Okay. Yes, so you wanted to say something?
Yes. I was going to plead with you and the leader of government business that instead of Monday we make it Tuesday, because the extortion. Friday, most of us go to our house.
No, I have to be done. It's not for anyone that we are adjourning to Monday. Okay. It's for me.
Okay.
I'm leaving the jurisdiction on Monday.
Okay.
So I'll come here in the morning to make sure we conclude.
This is the speaker.
Yes, it's for me, not for anyone. Because I'm leaving the jurisdiction on that same morning at night. So please, honorable members, you have to bear with me on that. Then, honorable members, I am fight. Okay, when we go to committee room 1, we have certain conversations to do. So yes, leader of government business.
Mr. Chairman, I cannot do my motion when your meeting is covered.
Yes, resume the house. The house is yours. Yes, Mr. Minister, you may leave. Thank you very much for coming today. Mr. Minister, thank you very much.
Mr. Chairman, Mr. Speaker. Mr. Speaker, first, thank you for I made a request. Me and my colleague on the other side, you have honored by lobbying us in a very good interest of our survivor. Thank you for your patience and listening to us. That's what I have to do to every member of the cabinet. Mr. Speaker, first I stand on SO51. I stand on SO51 for the House. Mr. Chairman, you please, Mr. Speaker, you please. Mr. Speaker, I stand on SO51 for this House to take resolutions for us to sit on Monday the date, Monday the 10th of August 2026. Mr. Speaker, I so move that this House to take a resolution to sit on Monday, the 10th of August 2026. I so move, Mr. Speaker.
I so second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it.
Motion moved by the leader of government business for the House to sit on Monday has been carried.
Are you not suspending any standing order? Mr. Speaker, I'm now coming. I have laid my foundation. I want to build this skyscraper. Yes. Mr. Speaker, as you have been an amendment to the Constitution, I will start my application for the Constitution itself. It is a very serious business, no matter how to live in the Constitution. Mr. Speaker, I stand on the Constitution provision 94 to regulate ourselves, to make this application. Section 94 of the Constitution, Act number 6 of 1991. Mr. Speaker, I also stand on SO82 to suspend a particular provision in the standing orders, SO59, the whole of SO59, to allow us to finish the business of constitutionality. Mr. Speaker, I so move that my amendment be accepted by my proposal be accepted by this House for the suspension of SO59 using all the other provisions. In fact, see the wrong note. Mr. Speaker.
Any seconder? Any seconder?
Yes, second.
All those in favor say aye. Aye. Those against say nay. The ayes have it.
Motion moved by the leader of government business for the House to continue proceedings on the Constitution of Sierra Leone Amendments Act 2025 on the 4th session of Parliament has been carried.
Honourable members, this particular session is moved to Monday, the 10th of August 2026 at 10 a.m. prompt. But this sitting is adjourned to Friday. This session is moved to Monday. This session is moved to Monday. The sitting is adjourned to Friday at 10 a.m.
Here is how to activate KidZonet for your child's online safety. Dial *499#. From the menu that appears, press 8 to select KidZonet. Next, press 1 to proceed. You will be asked to input your PIN to manage your services. Then select 1 again to activate the service. You will now be asked to choose your payment method. Then press Send. Confirm your choice by pressing 1. You will also be asked if you want the service to renew automatically when your subscription ends after 30 days. KidZonet will be activated instantly. Your child's online space is now safer and under your control.
For 2 decades, Integrated Power and Control Solutions IPCS Sierra Leone Limited has been meeting all your power needs. We are the leaders in quality power generators and control panels. From generators to a comprehensive range of world-class oil, lubricants, greases and solar air conditioners, AC/DC hybrid and solar investors, and we are the high voltage specialist for transformers. IPCS has it all. We will assist you in every aspect of the purchase and support of your FG Wilson Perkins generator sets. From installation and commissioning to support and maintenance, you can depend on IPCS. We provide quality FG Wilson diesel and gas Perkins generators backed by expert advice and technical support. We offer whole life cycle support for FG Wilson Perkins generator sets, from specification and installation to aftermarket support elements, including FG Wilson genuine Perkins